We don't have time to get into anything, but good morning and welcome back to W4Nevada Live. My name is Matthew Winterhawk. We're continuing coverage, day number 11 of Coyote Springs LLC versus the state of Nevada. Thank you for tuning in. If you're wondering why it's silent right now and you can see the video and there's no audio, that's because they haven't given us the audio feed yet. And they will once they get to the all rise and all that comes in, you'll hear the audio come in. And sometimes they leave this on and you'll hear this background conversation. So it's kind of a curse and a blessing to them at the same time.
Versus state of Nevada, appearances of council, please identify parties and party representatives who are present today.
Thank you. Our Mark Hutchison and Todd Kennedy and Kevin Sutall on behalf of Coyote Springs Investments LLC and related plaintiff entities. And on the stand with us is general counsel for those entities, Ms. Mary Clark.
Good morning, Your Honor. Jeffrey Sylvester and Matthew Nealand of Sylvester and Plenty on behalf of the state of Nevada.
All right, Ms. Cardinal is retaking the stand. You realize that you're still under oath?
Yes, I do.
All right, very well. You may resume.
Thank you, Your Honor. Ms. Cargo, you may recall that we left off yesterday with, you know what? Yes, thank you. Your Honor, counsel and I have conferred, and yesterday we admitted exhibit 126, but only a page 005. And then we admitted 127 and only a page of that document, which was 077. Council now has kindly stipulated to the admission of both of those documents, so we don't have to break them up. And it could probably be much easier for the clerk and for the court. And so, Your Honor, I would just offer exhibit 126 in its entirety and exhibit 127 in its entirety.
No objection, Your Honor.
All right, they're both minutes.
All right, so Ms. Cargill, let's go, if we can, please, back to what we were talking about yesterday before we broke, and that was exhibit 534, which is a lengthy exhibit, but we were going through selected portions of that exhibit. And they had to do with, as you can see on the screen there, 001 documents produced by Wells Fargo. All right, so let's go ahead and go now. I believe we left off on page 818. So if we could pull that up. And Ms. Cargill, can you just describe where we are in terms of the loan process and what document this is?
Maybe just have a moment with Mr. Hutchison, please. Yeah, no, yes, yeah.
Okay, okay. Your Honor, counsel has told me that on Zoom right now is Mr. Adam Sullivan. Mr. Adam Sullivan, he is going to be both a fact witness and an expert witness. The witness who will follow Ms. Cargill is in the courtroom right now, Alan Richards, who is one of our experts. Mr. Sullivan wanted to be present for, of course, counsel's entitled to have him present for that testimony. We'd like him not to be present for Ms. Cargill's testimony just because of the exclusionary rule. And counsel and I have agreed that he could come off of Zoom during Ms. Cargill's testimony and then come back on Zoom during Mr. Richards' testimony.
That's correct.
All right, so ordered.
Mr. Sullivan, did you hear that?
I've also relayed the message.
Okay, thank you.
Mr. Sullivan, can you hear us in the courtroom?
I did, yes. I'll exit the meeting and resume later.
Thank you.
Thank you so much. Thank you, counsel. Thank you, Honor. Okay. Ms. Cargill, back to our exhibit 534, and I had taken you to page, which I think is either the next page or where we left off yesterday, page 818 of that exhibit. And can you just orient the court in terms of what this document is and where we are right now on this page?
This is the first loan agreement between, as we saw on the first page we looked at yesterday, the loan agreement from September of 2005 between Wells Fargo and Coyote Spring Investment. And we also looked yesterday at the guarantee, the completion guarantee for this, dated of the same date in September of 2005. And this is that loan, it's a part of that loan agreement.
All right, let's go to page 829 of exhibit 534, please. And Ms. Cargill, what do we see here just in terms of really what I want you to is the signature page?
Okay, I think we need to go to a different page.
Is it 829?
That's the page we're on. The signature page should be beyond this. This is only page 61.
All right, what about, so I've got I got page 95 of the document at the bottom. So maybe we could just reference that, Hunter. Just go to the page number at the very bottom. I'm sorry? 863. Thank you so much.
Yes, and so this is the signature page for that loan document that we have been looking at. And you can see the commitment amount below Wells Fargo's signature to make sure that we're looking at the same loan. And you see the borrower's signature there as well.
And who's signing on behalf of Coyote Springs Investment LLC?
It's stated to be Mr. Harvey Whittemore.
Right. Let's go to the page. Now go to page 834. Go to page. Let's go to page 5. Let's see, 5. I'm sorry, 5310, please. Yes. Yeah, I'm sorry, same exhibit 534. And now we're gonna go to 534010. So now this is, Ms. Cargill, just if you could just highlight maybe the first, let's just say the first 1, 2, 3, 4 paragraphs at the top there, Hunter, please. There we go.
This is an amendment to the same agreement that we've been looking at, and it's stated to be amendment to revolving credit agreement. And this is dated December 2nd, 2005, between the borrower Coyote Spring Investment, Wells Fargo Bank. And it also is not only Wells Fargo, but now it's includes Bank of the West as a lender. And in the whereas clause that is at the bottom of our current screen, it states that the credit agreement, the parties hereto desire to amend the credit agreement, the guarantees, and the other loan documents to add defined term BOW, which is Bank of the West, as a lender to increase the total commitment amount to $50 million and to modify certain terms and conditions of the credit agreement.
Thank you. Let's turn to page 015 of that document, please. Thank you. Can you identify the signature line on behalf of Coyote Springs Investment LLC, please?
Yes, that shows Coyote Spring Investments has signed it as well as Wells Fargo. And if you go to the next page in the document, then you see Bank of the West, because they came in and they brought the additional $20 million in, as it describes on that page.
All right, thank you. Now, if we can go to another document, related document, which is on page 023. And just highlight the very first paragraph, please. What is this document, Ms. Cargill?
This is a guarantor's consent and reconfirmation, whereby the guarantors to the loan that we just looked at, the amendment, are reconfirming their guarantee. And in this paragraph, in the second to last line, it says, and the principal amount covered by each guarantee to $50 million.
Thank you. Now, if we could please turn to page 25, and could you identify the signators on this page?
Yes, it's dated December 5, 2005, and this shows Mr. Harvey Whittemore's signature.
And is he doing this on behalf of CSI or in his individual capacity?
That's stated to be in his individual capacity.
All right. Next document I'd like to turn your attention to is on page 219. And Ms. Cargill, this is dated July 5th, 2006. If we can pull up the first paragraph, please. And what was your status in terms of your employment with Coyote Springs at this time?
I was in July of 2006, I was an employee of the company. I'd started in May of 2006.
Okay, and as we've heard already, you served as general counsel at the time?
Yes, and I was involved from very early on in looking at loan documents and working with both internally at Coyote Springs and also with Mr. Tom Sino's office as well.
Okay, and from this time forward then, throughout the Wells Fargo documents that we'll review with you, were you then general counsel and involved in these loan transactions and the related documents?
Yes, I was.
Okay, so can you please explain to the judge then what the purpose is then of this document we're looking at on page 219?
Just for the record, may I just reassert my continuing relevancy objection, please?
Yes. Overruled, but it's standing objection.
Thank you.
Thank you, Aaron. All right, so let's just go down. First up, have you highlighted any parties different?
No, this would be the same parties, Coyote Spring Investment, Wells Fargo Bank, and Bank of the West.
Okay, let's go ahead and highlight the fourth paragraph, please. Next one. There you go.
And this states the purpose of what this Amendment 3 was. The parties hereto desire to amend the credit agreement, the guarantees, and the other loan documents to increase the total commitment amount to $75 million and to modify certain related terms and conditions of the credit agreement.
Thank you. If we can go to page 222, please, and just highlight section 3.1 at the top, please. Ms. Cargill, what's the effect of this provision in CSI?
Borrower Coyote Spring Investment is reconfirming all of the representations and warranties and all the terms and conditions of the loan documents. And it states, as of the date of this amendment and as of the effective date, and further represents and warrants to administrative agent and lenders that as of the date hereof, there exists, and as of the effective date, there will exist no event of default or defaults.
Thank you. Let's go to page 223, please. And can you identify who signed on behalf of Coyote Springs Investment LLC?
There were several signatures, but Mr. Whittemore was the first signature there as the manager.
Okay, let's go to the next page. And what do you see on this next page? 224.
On this page are the balance of the other two signatures, Mr. Tom Sino and Mr. Larry Gunderson.
Thank you. All right, let's go to a related document. This would be on page 229. Oh, okay. Can you please highlight under the first paragraph? Ms. Cargill, what is this?
This is the associated guarantor's consent and reconfirmation for the amendment to the loan agreement we just looked at. And this guarantee confirms the $75 million loan the increase to $75 million, and the guarantors signed this reconfirmation to reconfirm their obligations personally to the lenders.
Okay, let's turn the page then to 230, or actually go to page 231. And once again, can you identify who the signature is on this page?
On this page, we see Mr. Whittemore's signature.
Thank you. Now, if we can go to the next document, which is on page 439 of this exhibit 534. Ms. Cargill, can you please describe for the court? Let's go ahead and highlight the first full paragraph there and just inform the court here what this document is.
This is a full amended and restated revolving credit agreement. It is between Coyote Springs as the borrower, and then there's a variety of other borrowers that were added. Some entities from Northern Nevada, Winterhawk and Wingfield, but in particular for Coyote Springs Land Development Corporation, Coyote Springs Land Company LLC, Coyote Springs Nursery were all added as borrower entities. And then it identifies Wells Fargo Bank as the administrative agent and sole lead arranger, because this particular loan from June of 2007 was a syndicated loan, meaning Wells Fargo went out and brought in in addition to themselves, 6 other lenders to the loan. And it was a total loan amount of $150 million.
And what was the significance of Wells Fargo going out and getting other borrowers through syndication?
That it was a big deal. This was a very big loan. It was going to allow Coyote Springs Investments to move forward and construct and draw down on this loan for all of its obligations to construct items and facilities at Coyote Springs, so that Coyote Springs's part, CSI's portion of day one, our golf clubhouse, whatever Coyote Springs was going to be building on that day could come to fruition. And this was the financial wherewithal behind all of that.
Thank you. Let's go to page 552. And what is this, Ms. Cargill?
These are the like seven total lenders that came in for the total commitment of $150 million. So we see Wells Fargo Bank, Bank of Scotland, Key Bank National Association, Redwood Capital Finance Company, Bank of the West, Nevada State Bank, and Shanghai Commercial Bank. And you can see their pro rata share of the loan and the total amount each of them were committed to funding.
Thank you. as counsel for the company, were you required to provide any particular legal opinion in connection with this loan?
Yes, I was and I did. I provided a legal opinion to Wells Fargo Bank related to the Coyote Springs entity's corporate authorization and enforceability of the documents against the Coyote Springs entities. And I didn't do that lightly. That was that was very serious. That was one of the things I had done while I was at Lionel Sawyer and Collins were opinion letters to lenders. And we were all well trained by Mr. Zucker on the importance of that and what it meant. And I knew what it meant and how the banks relied on that. And it was significant that I did so. I didn't do so lightly.
Thank you. All right, let's please turn to same document. Within the same document, we're going to go to page 443. Ms. Cargill, I'm going to have the collateral paragraph or provision magnified here, and can you please comment on this section?
This provision, it defines what the collateral is for the loan, and it describes any real or personal property directly or indirectly securing any of the obligations or any other obligation of a person under or in respect of any loan documents to which it is a party pursuant to a security document relating directly or indirectly, parenthetical, for example, related water rights, and parenthetical, to an eligible property, including but not limited to the Coyote Springs collateral as defined in Exhibit K to this agreement.
Right. So in general, what property secured this loan?
On behalf of Coyote Springs, it was all of the Coyote Springs property that's Coyote Spring Investments or Coyote Springs Nursery or Coyote Springs Land Company or Land Development Corporation owned in the Coyote Spring Valley, and as well as the water rights. As we saw, as we went through some of the state engineer files, those reports of conveyance, and then the release and reconveyances of those when the loan was eventually paid off.
Thank you. Let's go to Exhibit K, which is referenced here in the collateral provision. That's on page 597. We could go there, please. Carter, this is is this the Exhibit K here that was referenced previously?
Yes, it is.
Okay, and can we just highlight Coyote Springs collateral, Hunter, and if you would highlight just A through G, please. Thank you. Ms. Cargill, what is the purpose of this provision?
It describes what I just said about what the collateral is at Coyote Springs. Item A talks about the fee and leasehold interest in the entire site, except for any property that's conveyed to Party Homes of Nevada. And then it talks about in item B, the purchase property remainder and the various other rights related to the Pardee agreements. Item C, again, it's more about the Pardee agreement and the fact that the rights of Coyote Springs under the option agreement, the Pardee multifamily purchase agreement, and the custom lot agreement are also being secured. Talks in item D about sellers' entitlements and rights under the general improvement districts, the GIDs, and any to be formed special improvement districts, parenthetical SIDs. And then in item E, it says is about the water rights that are a part of the collateral. And it states, except for those water rights transferred to the Clark County Coyote Springs Water Resources General Improvement District for use at certain of the borrowing based properties, all water rights, whether vested, permitted, or certificated, in which Coyote Springs, CSLDC, CSLC, Nursery, or any affiliate owns or hereafter owns any interest, and which water rights are pertinent to the entire site, whether in whole or in part, including without limitation the water rights set forth on Schedule 7.1X. And then item F and G relate to other rights and interests of Coyote Springs and its affiliates related to the ownership and development of the property overall.
Okay. Let's just maybe spend a little bit of time on subsection E. There's a schedule referenced at 7.1X, and let's turn to that schedule, because what is actually being identified in Exhibit E by way of collateral?
The water rights and the specific water rights that the bank was going to be seeking to have a security interest in.
Okay, so let's now go to, we can take a look at that at Schedule 7.1X, and that's on pages 558 and 559. So, Ms. Cargill, let's start with the first. Hunter, if you could start up at the top where it says water rights currently available, and then go down to the 3,140 figure just below that. Just highlight all that. Yep, perfect. Okay, a little bit, great, that's fine. Oh, that's fine, but I really want to just focus on, Hunter, just come up, keep going, keep it coming up, and then we'll highlight, great. And then we'll just do this in 3 sections. Okay, Ms. Cargill, what do we see here? Now, this is back in I guess June, is that right? June of 2000?
June of 2007.
Okay, June of 2007 is the date of this agreement, and what is being shown here on Schedule 7.1X.
So the very first words in bold right below 7.1X is a description of what 7.1X is. That bold section goes with the title of the document, and it says water rights currently available, parenthetical, or in the process of being assigned or acquired for availability, and parenthetical, for the development of the borrowing based properties owned by Coyote Springs. And then we get to that first box, and that shows the water rights, and you see the total at the bottom, and this box, and I'll describe what's in the box. I'll say that what the bank identified and what Coyote Springs identified this as is the remaining CSI owned water rights available for development within the Coyote Spring Valley Basin as of June 1, 2007. And the total is 3,140. And this schedule, this box, shows the 8,600 acre feet of permitted groundwater, and the comment is included in initial purchase of the property. So that's the Aerojet water that we've talked about.
That you referenced on Courts Exhibit 13.
Yes. And then the next line is the 5,000 acre feet of water that says additional purchase by CSI. That's the NV Energy water that's also on the Court Exhibit 13. And then the next line item should be have parentheticals around it because it's subtracted out. It's the 9,000 acre feet that was sold to Southern Nevada Water Authority, which is the combination of the 3 water rights that were sold, the 7,500 acre feet, the 400 acre feet, and the 1,100 acre feet.
All is shown on Courts Exhibit 13.
Correct. And then this also identifies the water that is to be dedicated for the preservation of the Malapadace. The 460 acre feet is then subtracted out. And then it describes the first 1,000 acre feet, which is subtracted out as well, that was conveyed to the Clark County Coyote Springs Water Resources General Improvement District to serve the project. And so the math of all of those numbers is 3,140.
All right. Now, why is that different than the 4,140 acre feet that you have written and testified about in Courts Exhibit 13?
Because I did not identify on Courts Exhibit 13, I didn't distinguish in the 4,140 between the water owned by the GID and the water owned by Coyote Spring Investment. And this schedule identifies the water that is owned by the GID, the 1,000 acre feet. And so that is why the total on the bank schedule is 3,140.
Is this bank schedule consistent with Exhibit Court's Exhibit 13?
Yes.
All right, so is it significant that in two places, Coyote Springs in this agreement with which you were involved as counsel, you used at the very top, water rights currently available. And then at the bottom, and after the 3,140 acre feet figure, the word available is used again.
Yes, that was significant because the bank was relying on,
Action Foundation, Your Honor. That's to the bank relying.
Your Honor, she was involved in the negotiations of this document and interacting with the parties and actually was involved in drafting the document. I think she can say. Please continue.
the bank was relying and Coyote Springs was making the representation to the bank that this water, 3,140, including the 1,000 acre feet being held by the GID, was, as it says, available for development within the Coyote Spring Valley Basin as of June 1, 2007.
Thank you. All right, now let's just shift down. Hunter, let's pull up the very first paragraph before the chart. And we're going to go down to 47,000. There you go. Good, perfect. All right, Ms. Cargill. Now this is a second section. Can you please describe for the court what is being reflected on Schedule 7.1X in this part of the agreement?
Coyote Springs was demonstrating to the bank and representing to the bank what this says, which is the list below reflects CSI's pending applications and pending acquisitions within the Coyote Spring Valley Basin that can be applied to Coyote Springs. So,
Please continue.
okay, the first line is says 9,000 acre feet, and it is referring to the same 9,000 acre feet that CSI sold to Southern Nevada Water Authority. And Mr. Whittemore had, it, as it states here, was talking to Southern Nevada Water Authority about repurchasing. And we know that did not happen.
Okay.
The next line, the next two line items refer to groundwater applications in the Coyote Spring Valley Basin. Those are the groundwater applications that we have spent time talking about that then were the subject of Order 1169 and subsequent rulings 6254 and 6255. And we know that through rulings 6254 and 6255, the pending applications were not approved. So those, that was simply something that was pending that didn't come through. And the next line item is 2,500 acre feet of water in the Coyote Spring Valley Basin that CSI was seeking to acquire from Nevada Power Company, and that also did not occur.
Okay. Now, you see the total 147,595 acre feet. Is it significant, or was it then significant that Coyote Springs described those water rights, not water rights, additional water rights potential within the CSV basin as of June 1, 2007?
Yes, because those were water rights that Coyote Spring Investments was seeking to acquire. And had they been able to acquire those, that would have been a great benefit to Coyote Springs. But as I just described, they did not come through to fruition.
Okay, so of that 140,590 acre feet, what eventually came to fruition out of all those?
Zero.
All right, now let's go to, if we can, this, and we're going to need to highlight Hunter 2 pages here. So the next, just come down to the very bottom of 5558, and we'll highlight that last paragraph, and then we're going to try to put it on top of the chart on page 559. Yeah, there we go. Okay. So now this is a continuation then of the collateral schedule. And Ms. Cargill, can you please describe what is happening in terms of representations or statements by Coyote Springs in this collateral portion of the loan agreement?
This is as described in the statement right below the box, which we can see a portion of it on the screen, potential within other basins as of June 1, 2007. And we'll look at that after we go through the chart. But the header over this box says this list below reflects other off-site water rights either owned, parenthetical, i.e. CSI, Tuffy Ranch, and parenthetical, under option, parenthetical, i.e. Cane Springs and California Wash Basin, and parenthetical, or under application, i.e. Lake Valley Basin, and parenthetical, by Tom and Harvey, parenthetical, i.e. CSI, Tuffy Ranch, and parenthetical, that may be used for the benefit of Coyote Springs by either being used within Coyote Springs, being used to maintain economic activity in Lincoln County, or being used to satisfy mitigation requirements that may be imposed by the Nevada State Engineer or the Fish and Wildlife Service. And then the list goes through all of those water rights.
Okay. And you could go through any of them that you think you need to highlight there, but let me just kind of get to the bottom line. It shows 140,250 acre feet that could be potentially available. Can you shift it up a little bit more, Hunter? Yeah, shift up just that a little bit. Other way. There we go. Was it significant and was it intentional on CSI's part to use the word potential in connection with this 140,258 figure?
Yes, because in June of 2007, these water rights on this schedule were potential within other basins. And it wasn't all related to Coyote Springs. Some of it could have been or is, as the paragraph before identifies, but some of it was never intended to leave Lincoln County because it was, for instance, there, as it states, being used to maintain economic activity in Lincoln County.
All right. Now, I note that there's some references here to what you have described already, Courts Exhibit 13. Can you comment on those? Let's just start there, maybe in that chart, and then you can go to others that are not within your chart, which was Courts Exhibit 13, please.
Okay, then we'll start with Cane Springs. So the Cane Springs is 4 lines down, and it says 1,000 acre feet of groundwater permitted in Cane Spring. And the comment is under contract to purchase from Lincoln County Water District / Vidler. And that is the 1,000 acre feet that is shown on Courts Exhibit 13. And as I described, the status of it yesterday, that what the ownership of that 1,000 acre feet is today. But at the time, it was simply under contract and none of it had yet been acquired at that time. But that's what that 1,000 acre feet is. And then right below that, it also says 17,000 groundwater applications in Cane Spring Valley, and that never came to fruition. So that never became a part of the contract. And then if we go down, I'm trying to find the 11,300. It would be the number that says 74,929 in the far left column. That's the applications in Lake Valley. That was the change applications that were subject of as we've been describing in the Tuffy Ranch hearings. And it states in the comments, pending approval of applications, intended place of use is Coyote Springs. And we know from having looked at ruling 5918 that 11,300 acre feet became permitted to be moved to Coyote Springs through a pipeline in the future. As we discussed yesterday with Courts Exhibit 13, that's 0. It was 0 in 2007. Well, I mean, it wasn't even completed yet, but still 0 today, as we talked about yesterday.
Okay.
And then let's see the other things we can talk about that we talked about yesterday. There's it says 99 surface decreed Upper Moapa Valley, evidenced by shares of the Moapa Valley Irrigation District. That's the Muddy Valley Irrigation Company water that is owned by Coyote Springs. And it's shares, and I don't know who did the calculation on that 99 acre feet. I don't know what the calculation is. I think we also saw on an exhibit that Mr. Sylvester and I went through a different number that was calculated. So it may be that the company changes, meaning Muddy Valley Irrigation. I don't know why that's 99.
But is this what was referenced and you discussed yesterday with
Yes.
Exhibit 13?
The 16 preferred shares and the 19 common shares.
Okay.
And then we have the California wash water, which is 25 acre feet groundwater permitted in the California wash. And it says CSI purchase conditioned on state engineer's approval of a change application. CSI completed the purchase, but I do not know about approval of a change application. I've not seen approval of a change application. Maybe I've missed it, but I've not seen that. But I do know CSI completed that purchase.
And is that what you also addressed yesterday with the court on your court's exhibit?
Yes, it is. It was for the Moapa Dacer Muddy Valley Moapa Valley Irrigation or Moapa Valley Water District.
Okay.
And then right above that is the 20 acre feet that we discussed yesterday that I described also as certificated. And it says MV, that means Moapa Valley. And it's owned by Coyote Spring Investment and committed to Moapa Valley Water District under the backup water supply agreement. So those are all the rights, I believe, that were on the chart that we talked about yesterday. The rest of the rights.
Before you move on, and these were what was pending or the potential in 2007. And did any of these things change or otherwise make water available that is different from what you testified to yesterday with Court's Exhibit 13?
No,
Okay, so now we've got other potential water opportunities that you have not talked about in Court's Exhibit 13.
correct.
You can go through each one of them individually if you like, or you can just answer this question. Did any of these come to fruition that would make water available at Coyote Springs for purposes of development?
No, they're all within Lincoln County, or there's one in Moapa Valley, but they're all otherwise, they're not for Coyote Springs.
Okay, so let me just kind of go down here. It's of the 140,258 acre feet. How many acre feet are available through this recitation in this chart for purposes of Coyote Springs development in 2008, 2020 time period, as you were talking about yesterday with the Court's Exhibit 13?
None.
Okay, that true? Does that continue to be true today?
Yes, it does.
All right, and I just all right, thank you. Is there anything else you think that the court should know about concerning this collateral of water rights that we've been discussing within Exhibit 534, pages 558 and 559?
No, the only collateral that was given was what we saw when we went through the records of the state engineer's files, the Coyote Spring Investment owned water rights.
We talked about that a long time ago during your direct.
Yes,
All right.
we did.
So let's not replow that. All right, schedule, let's see, let's move if we can within the same, again, same loan agreement, but let's go to page 599, please. And can we just highlight party agreements in just that first paragraph? And Ms. Cargill, can you explain to the court, please, what this provision provides?
This is a representation and warranty by Coyote Springs, the Coyote Springs borrower entities to the lenders regarding the party agreements. And then there are a handful of things that are being represented and warrantied, but in essence that they're all in full force and effect and they're in good standing.
Thank you. Can we please go to page 601 within the same loan document? Ms. Cargill, I'm just going to have highlighted subsection D at the bottom there, just that part. Can you please describe for the court what is being represented here by Coyote Springs?
It states that Coyote Springs shall comply with all requirements regarding water rights as set forth in the option agreement. Romanet 2, provide to administrative agent for its reasonable prior approval, any agreements proposed to be entered into with any third party pertaining to water rights owned or leased by Coyote Springs or any affiliate during the term.
Thank you. Ms. Cargill, you mentioned that you were and testified that you were involved with this agreement and have in fact been involved in the drafting and negotiations. Would CSI agree to this provision, this subsection D, Romanet I, if its 441 acre feet of water rights that we just reviewed weren't actually available for development as represented to the bank in Schedule 7.1X?
Objection Foundation calls for speculation.
Foundation.
Were you involved in the draft of this document?
Yes, I was.
All right. And were you, in the course of drafting this document, someone who would determine whether or not certain representations would be made to the banks?
Yes,
And would you be involved in the way in which those representations would be drafted?
yes, I would have reviewed them and we would have talked to the lender about them and negotiated with them.
And would your drafting of the language of the provisions in this document have been informed by your knowledge of the actual facts as they related to the water rights concerning CSI?
Yes, in particular, because I knew that I was going to be giving an opinion letter related to this loan, and I would have been paid particular attention to all of the representations, warranties, and covenants being given by the Coyote Springs borrower entities.
Thank you. Would CSI agree to this subsection D, Romanet 1 representation to the lenders if its 441 acre feet of water rights weren't actually available for development as represented to the bank on Schedule 7.1X?
Again, Your Honor, Foundation, it's Mr. Whittemore that signs the document, and she can't say whether or not Mr. Whittemore would or would not have agreed to the provisions of this agreement with respect to the amount of water available. That's not within her foundation.
No, that wasn't my question. My question was, would she have, or would Coyote Springs have made this representation, being somebody who's involved in the negotiations, involved in the drafting of the document, and as a lawyer? Would she have actually, or Coyote Springs, based on her involvement and position with Coyote Springs, have agreed to this provision that Coyote Springs shall comply with all requirements regarding water rights as set forth in the option agreement if the 441 acre feet of water rights weren't actually available for development as represented in Schedule 7.1X?
It's an incomplete hypothetical, Your Honor. There's a significant amount of collateral that they haven't yet spoken about with respect to, or that supports this loan. And again, it's an incomplete hypothetical. It doesn't discuss the balance of the water rights that have already been testified to and the potential water rights.
Overruled. Thank you. Ms. Cargill, I repeated the question 3 times. You need it one more time?
I think I can remember it. No, Coyote Springs would not have entered into this if it did not believe that its collateral was as Schedule 7.1 described.
All right. And let's continue on within this agreement concerning additional representation and warranties made by Coyote Springs, whoever the borrowers were. And let's go to 603, please. Now, this is still the same loan, still Schedule K?
Yes,
Okay, let's highlight, if we could please, that paragraph 5. And Ms. Cargill, if you could just describe for the court what representations and warranties are being made here by Coyote Springs or the borrowers.
these are additional representations and warranties. Then they're warranting, for instance, in sub A to a list of material contracts. And then it goes down a little bit further in sub C, and it says adequate water is projected to be available to permit full development of the Coyote Springs property on a timetable consistent with the projected development schedule, therefore, and consistent with the types and density of projected uses for the property. So that was an additional representation and warranty by borrowers to the lenders.
What's the significance of that representation to CSI?
That what we just finished talking about, that Coyote Springs is telling the borrower or the lender that adequate water is projected to be available to permit the full development on a timetable consistent with all of the schedules and the projected timetables that have been provided and consistent with the types and density. That's important.
Thank you. Let's turn the page to 603, please. And if you could please highlight section 6, just the first maybe 1/3 of that. You're certainly welcome to comment on whatever portion you'd like, but I'd like to focus your attention on this section. If you can describe for the court what this section is addressing. Again, still within Schedule K, the representation and warranties.
Yes, and so this is an additional provision where Coyote Springs is telling the bank, Coyote Springs currently owns approximately 3,600 acre-feet per annum of water rights for the Coyote Springs property as permitted by the Nevada State Engineer. A parenthetical, a true and correct copy of which has been provided to administrative agent.
Thank you. Once again, in your role as general counsel and being involved in negotiating this case, this agreement and drafting it, would CSI have said what it said here in section 6 under the reps and warranties, if it thought that the permits that it had and owned were simply a right to try?
Just a speculation foundation, Your Honor.
Overruled.
No,
Why not?
because this is a representation and warranty in a loan that is secured by all of the property at Coyote Springs by its water rights with personal guarantees by Mr. Whittemore and Mr. Tomsino. And that they wouldn't have done that. I mean, this is a very clear statement. Coyote Springs currently owns 3,600 acre-feet per annum of water rights for the Coyote Springs property.
Thank you. I'd like to go next to, and we don't have to spend a lot of time with this, but section 7 addresses the Nicholas PGA golf agreements, and we've heard a little bit about that during the course of the trial. How do these agreements relate to water rights we've been talking about?
They relate to the property overall and the water rights and the developability of the property. The bank was very impressed that Coyote Springs, and as I've spoken about before, these were big deal agreements to have gotten Jack Nicklaus Golf to agree to 3 golf courses for Coyote Springs and the Professional Golf Association of America to enter into an agreement and to agree that PGA West, a new center, could be developed at Coyote Springs. That was a big deal, and it was very important because you can't build a golf course without water, and you had to have the homes in order to be able to have the treated effluent to water the golf courses.
Okay, thank you. Let me ask now, within the same loan documents, you go to page 447. And if you could please highlight the very bottom, Hunter, or magnify the very bottom under guarantor, and do the same thing, or carry over to page 10. Ms. Cargill, with your involvement and also just seeing the content of this loan agreement, who guaranteed this $150 million loan?
It was guaranteed by Mr. Tomasino individually and through his various trusts that he had, as well as Mr. Harvey Whittemore.
Thank you. If we could turn next to page 455. Ms. Cargill, I'd like to have Hunter magnify the last section under the heading undeveloped land and go to the bottom of the page and just magnify that. Would you please explain to the court what this provision is providing and its purpose?
The portion that we can't see right now describes the undeveloped land that will become, as it says, undeveloped land is real property owned in fee simple by borrower and to which one or more of the conditions apply. And it describes as the types of collateral that are available, and it affects the amount that could be drawn down on the loan based on the type of property that it is. And so the undeveloped land has to meet either condition A, B, or C. And it has to satisfy the following paragraph, which is identified by, but which real property is fully entitled, including, and then it goes on to describe certain things. And in Romanet 3, it describes that the property would have to has sufficient access to roads, utilities, parenthetical, including water, end parenthetical, and other improvements and amenities to permit such full anticipated development. It goes on to say, for purposes of this definition, quote, sufficient access, end quote, to water shall mean water owned and controlled, parenthetical, or which will be owned and controlled in a timely manner for the planned development of the Coyote Springs project, end parenthetical, sub A, by Coyote Springs and usable with respect to the applicable real property, or B, any relevant public entity whose charge it is to allocate water pursuant to final maps pertaining to the relevant real property, such as the Clark County Coyote Springs Water Resources General Improvement District.
Was this provision significant for CSI?
It identified, yes, it identified something that was how Coyote Springs could have its land become a part of the borrowing base and the thresholds it needed to achieve in order to be able to draw down on the loan and to then move the property out of an undeveloped status into a developed status. There were other provisions of the loan that we're not looking at that relate to what it means to be developed property, for instance, and that changes the amount that can be drawn down on the loan.
Why was Coyote Springs making representations and warranties concerning sufficient access to water within the Coyote Springs development?
Because without sufficient access to water, the development cannot be realized. And that was the purpose of the loan, was to allow Coyote Springs to be able to develop the property as with homes and businesses, and to be able to put its water to beneficial use and build a casino, build a golf course, and sell custom lots with Pardee, and to do its own resort residential development that it was entitled to do.
Why was Coyote Springs also making a representation and warranty to the lenders that the water that it owned or controlled would be usable with respect to the project?
Because the lender would want to know that the water could be used for the project, because if the water can't be used for the project, the development cannot proceed. And the lender Coyote Springs was relying on that to get the loan.
Let's turn to page very quickly, page 540. You identify who the signatories are here on this $150 million loan.
For Coyote Springs investment, it was the various managers, and here we see Mr. Whittemore's signature as a manager.
Okay. And if we turn to the next page, who were the signatures here?
Again, for Coyote Spring Investments, it was Mr. Tom Sino and Mr. Larry Gunderson.
Okay, and if we go to page 543. Sign.
This shows the signatures for the other three borrower entities: Coyote Springs Land Development Corporation, Coyote Springs Land Company, LLC, and Coyote Springs Nursery, and Mr. Whittemore signed on behalf of each of those three entities.
Go to the next page. And just kind of page through those. Are these the signatures of all the lenders?
These are all the lenders showing their commitment amounts. So that's Wells Fargo Bank, $50 million.
Next.
Bank of Scotland, $25 million.
Next.
Key Bank, National Association, $25 million.
Next.
Redwood Capital Finance Company, $20 million.
Next, please.
Bank of the West, $10 million.
Next.
Bank of the West, again, 10 million. It was a second signature for Bank of the West. Nevada State Bank, $10 million. Shanghai Commercial Bank Ltd, $10 million.
Thank you. Right. I'd like to now turn to a new related document. When we turn to page 326 of exhibit 534, please. And would you please highlight the first full paragraph? Ms. Cargill, what is this document?
This is a guarantor consent modification and reaffirmation for the agreement that we were just looking at for the June 2007 loan agreement, and the guarantors are reaffirming their obligations underneath that agreement. And there are three, it's identifying the three guarantees that were delivered: the completion guarantee in Romanet 1, the repayment guarantee in Romanet 2, and the hazardous materials indemnity agreement in Romanet 3.
This is all for that $150 million loan.
Yes, it is.
All right, let's go to page 328, please. Can you identify the individual who signed the guarantee?
On this page, on April 2nd, 2009, this is Mr. Whittemore.
Okay, and
So this must be the wrong signature page because the loan was from June. There was another loan in April of 2009, but this is for a different loan.
okay. Let's go to, if we can, exhibit 5, we're still with exhibit 534, and we are on page 309. Ms. Carter, this is a 7th modification. Can you please highlight the first paragraph, Hunter? And would you please describe to the court what the purpose of this document is, please?
This is the 7th modification and dated April 2nd, 2009. And this added, it did a couple of things, but it also added a borrower, Coyote Springs Golf Operations, to the Coyote Springs entities.
Okay, let's go to page 311 of this document. If you highlight the first paragraph there, guarantor.
And the guarantee was amended pursuant to this agreement to add Mr. Albert Sino Jr. and his personally and through his various trusts as an additional guarantor.
As a result of this document, Mr. Albert Sino Jr. became a guarantor.
Yes, and the total, this agreement also, I think I can see it on the page, it reduced the total commitment to $100 million.
And that would be down at about 2/3 of the way down, total commitment amount.
Yes.
Highlight that for us, please, Hunter. All right, thank you. And if we go to page 312. And if you would go down about 2/3 of the way down, Hunter, highlight section 3, or excuse me, magnify section 3.10 and section 3.11.
Yes, this refers to the various repayment guarantees to ensure that they're all together, meaning not only Mr. Albert Sino, Mr. Tom Sino, and Mr. Harvey Whittemore are all guarantors, and they're all reaffirming those obligations under this modification and reduction to $100 million. So each of them are guaranteeing $100 million.
Mr. Whittemore and both Mr. Sino's.
Yes, and both Mr. Sino's.
Okay. And what is section 3.11? I guess it's section 7E.
That adds Mr. Harvey Whittemore. You can see that he is added. So it says each of the following completion guarantees are hereby amended as referenced in the guarantor consent modification and reaffirmations attached here to. 1 dated June 4, 2007, executed by TAS, TS Trust 1, TS Trust 2, and HW. And 2 dated February 19, 2008, executed by ADS, AS Trust 1, and AS Trust 2. And what that refers to is TAS is Thomas A. Sino, HW is Mr. Harvey Whittemore, and ADS is Albert D. Sino Jr., as is AS Trust 1. Those are Albert Sino's trusts.
Thank you. And if we go to page 314, we'll see some of the signatures that are here on this document. We don't have to should see all the signature pages. Do you know that Mr. Sino, both Mr. Sino signed on these documents?
I believe they both did. This signature page shows Mr. Whittemore, but yes.
Let's go to the next page. Excuse me, I'm sorry, stay on page 316. This would be Mr. Whittemore signing on behalf of Coyote Springs Investments, LLC. And if you go to the next page, 317, who is Mr. Whittemore signing on behalf of?
Mr. Whittemore signed on behalf of Coyote Springs Land Development Corporation, Coyote Springs Land Company, LLC, Coyote Springs Nursery. And then it is stated that Mr. Mommer signed on behalf of Coyote Springs Golf Operations.
Okay. And then we don't have to do that, but the lenders all signed on subsequent signature pages. Is that your understanding?
Yes, they did.
Now let's go to, if we can, please, within Exhibit 534, a new document. It begins on page 346. You can see this is July 13, 2010. Can we highlight that first full section there, please? And first, Ms. Cargill, is Mr. Whittemore still with the company at this time?
Yes, he is.
Okay. And what's going on just economically in July of 2010 in the Southern Nevada region?
As, yes, it is. We are in, I believe, what has been referred to as a recession. I believe Mr. Sylvester and I talked about that on my first or second day of cross.
Okay.
It was a recession. And then this paragraph indicates this is the 8th modification. And as you noted, it's dated July 13, 2010. And then it identifies all the Coyote Springs borrowers, all the ones that we've been discussing.
Okay. Let's go down to recitals D. And what is the purpose of this 8th modification?
The purpose was to convert the loan from a revolving credit loan to a non-revolving, to a term loan where it was set. The amount that was due at this time after a pay down that this 8th modification required was then the full amount of the loan. And there were no more draws off of this loan. It became a term loan with a due date.
All right, thank you. If we could please turn to page 347 of this document. And if you could please just highlight 1.7, 1.8, 1.9 of the page.
1.5 also.
1.5, sorry, 1.5 through 1.9.
So 1.5 is what I was just talking about. It reduced the total amount of loan. It was permanently reduced to $72 million.
Okay. And then but what 1.7?
Those provisions 1.7, 1.8, and 1.9 are a part of what was important at the time to the lender in order to only require the reduction of the loan to the $72 million, that the borrower was in compliance with all provisions, all conditions contained in the development agreements, the BLM lease, and the option agreement. And the option agreement refers to, as we saw defined in earlier documents, the part of the single family option agreement. And then number 1.8 is that party shall have performed and shall continue to perform its obligations under any and all of the party agreements. And then 1.9, all land use entitlements necessary for the proposed development of the collateral pool properties remain in full force and effect.
All right, thank you. If we can go down and highlight representations and warranties, please. Ms. Cargill, what's the effect of this provision on CSI?
The borrower and all the Coyote Springs entities were representing and warranting to the bank that that no default or event of default, breach or failure of a condition has occurred or would exist with notice or lapse of time under any of the loan documents. And it goes on to say, and that all of the borrower's representations and warranties herein and in the other loan documents are true and correct and deemed remade as of the date hereof, which representations and warranties shall survive execution of this agreement. And so it was important to the lender to know that borrower was still willing to stand behind all of its representations and warranties that it had made previously and all of the conditions and commitments it was making to the bank.
Including those that we had seen with the $150 million loan?
Yes, all of them.
All right. If we could turn to page 363. Um, I'm sorry, yes, 363. Page 363 now, same document. Again, we see Mr. Whittemore's signature on the various entities there. We don't have to go through all those. This is your understanding of what he did in terms of signing on behalf of these entities.
Yes, he was still present with the company and he was signing.
Okay, and then if we go to the next one, we'll finish out those signature pages there. Same thing, Ms. Cargill.
For Mr. Tom Sino, and then I think there's a signature page for Mr. Albert Sino also.
Okay.
Yes.
There it is right there. Okay. All right. The last document I'd like to look at in this series, Ms. Cargill, is on page 40. And this is a second amended and restated credit agreement. And the date of this appears to be February 7th, 2011. Is Harvey Whittemore still with the company?
No, he is not.
Okay, so by now he's left the company.
Yes, and that was the purpose of this second amended and restated credit agreement, and the last whereas clause refers to that.
Okay, if you pull up that last whereas clause. And that just
And it,
acknowledges Harvey Whittemore's left the company.
yes, it does, and it releases Mr. Whittemore from all obligations as a guarantor.
Okay, can go to page 133 of this document. Who's signing on behalf of Coyote Springs Investment LLC?
Mr. Tom Sino and Mr. Albert Sino Jr.
Okay. If you turn to the next page, that has Mr. Albert Sino Jr. signature.
Yes, it does.
Previous page had Mr. Tom Sino's signatures.
Yes, correct.
And 135, just to round out the signature pages for all those entities.
Yes, they each signed on behalf of all of the Coyote Springs entities, each of Mr. Sino Jr. and Mr. Thomas Sino.
And then we don't have to look at this, but the lender's signature pages follow for all the lenders.
Yes, they should have, yes.
Now, if I could have just one moment, please, confer with my co-counsel here. Ms. Cargill, thank you for your time. Those are all the questions I have on this witness.
Okay.
Morning, Ms. Cargill.
Good morning.
I'm gonna start sort of where we just left off, with council discussing the Wells Fargo credit facility. You seem to have a fairly good working knowledge of those documents. Would that be accurate?
Yes, and I refreshed my memory by going through the 1,200 pages that they produced.
Those are documents that were not produced by CSI. They were actually produced by Wells Fargo in the litigation. You recall that bait stamp at the bottom of those documents we looked at?
Yes, I do.
I want to talk about that syndicated credit facility. I think that was the document you were at least looking at in part. You know what document I'm referring to as far as the syndicated loan facility?
Are you referring to the initial June 2007 one? That was the initial one that was syndicated with the 7 lenders.
Okay. How much was that credit facility?
It was for up to $150 million.
And who were the borrowers under that credit facility?
We would need to look at it, but I will tell you who I think it was. I believe it was Coyote Springs Investment, Coyote Springs Land Company, LLC, Coyote Springs Land Development Corporation, and Coyote Springs Nursery, LLC. I believe also a borrower was Red Hawk Land Company. And I think the Foothills at Wingfield, I think it's just the Foothills at Wingfield LLC was also a borrower they were brought in under that facility as well for things related to Northern Nevada.
That's what I'm trying to get to. It was $160 million credit facility with those borrowers.
Up to $150 million. It was a revolver.
Do you know how much was actually advanced under that credit facility?
It ended up being over the $72 million, which is why it was paid down to the 72 million. I think that pay down required about my memory tells me $15 million, $14 million pay down. So somewhere north of $80 million.
Was advanced?
That's my recollection right now.
And what was the business of Red Hawk as one of the co-borrowers under that credit facility?
Red Hawk was not in the midst of doing any construction. It was to provide additional collateral to the bank.
And what collateral did it provide to the bank to support the credit facility?
Some undeveloped, I believe the golf course was secured as well, but Red Hawk Land Company owned, I think is probably the better word, some raw land at the time that was being used as security for that loan that was separate development property, as did the foothills at Wingfield also LLC also owned some raw land that was developed, had the potential to be development property as well at the time.
Were either of those two properties developed by Red Hawk and the other entity?
Mr. Sino and the two Mr. Sinos, Tom Sino and Albert Sino Jr. acquired some of the property from Red Hawk and from the foothills at Wingfield is what my memory tells me. And they developed some of that property. From 2007 forward, I do not recall that Red Hawk Land Company did any land development on its own other than operation of the golf course and maintenance of some of the property.
You didn't mean to suggest in going through the collateral base on responding to Mr. Hutchison's questions that the only real property collateral was the CSI real property. Is that correct?
That's correct. We were only talking about the Coyote Springs portion of the collateral. There was collateral from Red Hawk. There was land and water rights that was collateralized out of from the Red Hawk entities.
And we could look at that and find that if we were to go back and look at the entirety of the collateral base that was pledged to support the facility, right?
Yes, we could. I mean, all of it is attached to the loan agreement.
And you've done that because you have a working knowledge of the loan documents, right?
Yes, I didn't pay much attention to the Red Hawk side of it because that wasn't what I was looking at. I was looking at it to refresh my memory about Coyote Springs portion of it. I wasn't necessarily trying to refresh my memory about the Red Hawk side, but if you pulled it up and we looked at it all, we could talk about it.
Do you know how many acres of land Red Hawk owned and pledged as collateral for the facility?
I don't remember right now.
Okay, I don't have the document. Let's pull it up and see if we can't, you and I hunt for it. So we take a look at what the additional collateral base was. I think it's at the 534 or exhibit 534.
It would have been near the schedule 7.1,
Okay, let's.
somewhere near that exhibit page.
What do you have?
553.
553 maybe? Pardon me? Oh. Is that some of the real property collateral that's pledged?
This schedule 4.1 is honestly not real helpful. And I only say that because it's 2 pages, and if you look at what it describes, it doesn't say a whole lot. But it shows the entitled undeveloped land, developed land, Red Hawk non-golf course, and golf courses. But there's no actual dollar amounts or.
I may approach this a little bit. I can't quite see it.
Yes.
Standing. So you have, and whose property is the entitled undeveloped land?
I believe that is, we would have to find the defined term for it, but I believe that's Coyote Springs property, although theoretically it could be Red Hawk Land Company property also. But if you look at the appraisal basis and what it describes, I believe it's only referring to the Coyote Springs property.
Okay, and then the developed land, as is full finished lot value?
I believe that is again referring to it could be referring to Red Hawk Land Company. We would have to go through and tie it all the way out. It's simply the defined term developed land, and it's saying the advance rate is 70% of the appraised value. as the entitled undeveloped land shows, the advance rate is 50%.
So without drilling down and maybe taking a close look at those documents, you and I could agree that there was a significant amount of real property collateral pledged by Red Hawk and the other entities to support the facility.
Red Hawk, I don't know that I would call it significant. I mean, Red Hawk Land Company, if you took all of what Wingfield was at one time, is at its largest, including all the golf course, is under 5,000 acres.
Okay. And the other entity that owned real property?
Oh, I apologize for interrupting you. I was including the foothills at Wingfield as well within that generalized description.
Okay. And do you have an opinion today, the recollection as to the combined value of that other additional real property?
I do not. We would need to find the page that describes that.
And the borrowing base was the real property that we looked at and some of the water rights that were also pledged. Is that accurate?
Yes, that would be
And
accurate.
I think you said Red Hawk and the other entity also owned water rights. Were they too pledged?
I don't believe the foothills owned any water rights. Red Hawk Land Company owns water rights that it uses for watering the golf course.
To my question, please. Were they pledged?
I believe that Red Hawk Land Company's water rights that are used for watering the golf course were pledged.
And then I think you said, as I understand it, that the credit facility was for the purpose of improving the CSI property. Is that your testimony?
That was what Coyote Springs' purpose in entering into the initial credit facility and subsequent credit facilities was for Coyote Springs.
And is it your testimony, Ms. Cargill, that all of the money advanced under that credit facility was used exclusively for CSI and its property?
No.
Okay.
It was used by each of Coyote Springs, and we'll just say Red Hawk. And I don't know how much was drawn by Red Hawk, and I don't know how much was drawn by Coyote Springs. My understanding is that the bulk of it was drawn for Coyote Springs.
When you say my understanding, do you have today, sitting here today, have a foundation to say what the allocation of the amounts advanced under the credit facility is or was?
No, we would need to look at the specific pages that show what those amounts were
Okay.
that are attached to the loan.
And then it was also supported by the financials of Mr. Thomasino initially, and then Albertino. Is that accurate?
And Mr. Whittemore, yes.
Correct. And do you know what their financial wherewithal was at the time that they signed those guarantees that would support the repayment of the loans?
Not other than, and I did not look at those pages. I know there are pages in this packet that describe that, and I did not look at those.
Do you have some general understanding as to what the financial net worth are that the Cinos and Mr. Whittemore had collectively that would have supported the credit facility?
No, and total candor, I did not look at those pages. That was not a part of, when I looked at the 1,200 pages of this document, I did not look at their financial statement disclosures that are contained and are confidential that are contained in this document.
When you say they're confidential, you mean they're provided by the bank pursuant to my subpoena?
Yes, but I would also suggest that they shouldn't be, those numbers shouldn't be discussed in open court. That would be
I
my
appreciate that,
suggestion.
but we're talking about what collateral and what guaranteed the repayment of that debt. I want to understand if you know what the entire collateral base was and what the financial wherewithal of the guarantors were at the time, only if you know.
I do not know.
You were very careful, though, in reviewing the documents and making certain that everything that was signed and submitted and supported was true and accurate, right?
Yes,
And so you would have looked at the financial statements and made an indication that the financial wherewithal is as was represented by the guarantors, correct?
no, I would not have looked at what the guarantor's financial wherewithal was. That would have been for the controller and CFOs to be looking at and working with the lenders on.
You took your job very seriously with respect to submitted an opinion letter, right?
Yes, I did.
And so when you submitted the opinion letter, you looked at in part, the underlying permits. It's certainly the water permit that secured the loan, correct?
We've discussed those before, the 4,140 or the 4,600 acre feet, yes.
I didn't ask that. I asked, did you look at those in connection with preparing your opinion letter?
I don't recall if I looked at those specifically in 2007 as I prepared my opinion letter.
Well, certainly, as I understand it, you would not have, let me withdraw the question. My understanding is that you were careful in reviewing the records of the company and as it relates to representations and or warranties that were being made in the context of the loan and guarantees. Was that your testimony on redirect?
That I believe more or less states what I said on with Mr. Hutchison a few moments ago.
So you would have been very careful about looking at all of the collateral pledge, for instance, even the real property, to make sure that the owner could, in fact, pledge the collateral. Wouldn't that be something that you would do in your capacity?
Objection, asked and answered. Overruled.
I did review the property. I did review where it was in the loan documents, and I spoke with Mr. Whittemore and Mr. Mommer and Mr. Dirk and persons in Mr. Tom Sino's office, Mr. Larry Gunderson, who's now deceased. And I spoke to them and we discussed the collateral and what was in the documents as both on specific levels and general levels.
And back to my original question, you did a very close analysis of the permitted water rights, correct?
Objection, asked and answered. Overruled.
In connection with the schedule that Mr. Hutchison and I looked at, we talked about that amongst all of us within myself, Mr. Mommer, Mr. Savely, Mr. Dirk, Mr. Whittemore, and we reviewed that schedule and we talked about exactly what it said and made sure that it comported with what the permits and the rights that were held by Coyote Springs actually were.
And just so I understand it, you, in doing whatever you did in the context of making certain the representations and or warranties were accurate, you looked at the permits and had discussions with, among others, Mr. Whittemore, Mr. Mommer, and whoever else you did. Mr. Savely, was he part of that process too?
Mr. Savely, Mr. Dirk, yes.
And it's fair to say that because you're precise in the language that you negotiate and as a transnational lawyer include, nobody told you, that is Mr. Whittemore, Mr. Mommer, that those permitted rights were guaranteed. Did they?
We've discussed this before, Mr. Sylvester, and no one has said to me, those rights are guaranteed. No one has used those specific words in that order related to that.
And that's why you didn't put into the representations of warranties that water was guaranteed, right? Because you wouldn't want to do that.
I don't think.
Objection compound. Overruled.
Correct.
Because you knew that those permitted water rights were not a guarantee of water in the future.
Objection. Question's been asked and answered repeatedly throughout the multiple days of testimony.
Not in the context of her opinion letter and negotiation and drafting of this transactional document.
Overruled.
Go ahead.
Mr. Sylvester, those words are not in the loan agreement, and I did not issue an opinion saying that I did not issue an opinion on water rights. My opinion was limited to the corporate and organizational authority of the companies to enter into the agreement and to the enforceability of the agreement against the
Right, we
borrowers.
talked about the opinion letter, and now we were transitioning to the language that you would have reviewed and approved in connection with essentially directing your client to either sign or not to sign or caution him. That's what we were talking about. Remember that a minute ago?
Objection, argumentative of the witness.
I'm not arguing.
It's a premise for a question.
Remember that conversation?
Yes, I recall.
And you would not have recommended to Mr. Whittemore that he sign a guarantee if it included a commitment to representation and warranty that the water permits were guaranteed.
I think that's a fair statement.
All right, we'll take our morning recess now and
Okay, thank you, Judge.
reconvene at 22:11.
Okay, thanks, Judge.
All rise.
Alrighty, that'll be our first morning recess, and then we will put out our notes, contemporaneous notes from this first session here on day 11. Thank you for tuning in to W4Nevada Live. My name is Matthew Winterhawk. If you have any questions, comments, or concerns, please do reach out. We appreciate the feedback. Please share and put this out. We are being suppressed so heavily. This case is incredibly important. $1.5 billion judgment. Coyote Springs LLC versus the state of Nevada. In a takings claim where they believe that the state should be paying, and or I guess the taxpayers should be paying for their speculative losses in development while they still retain and have this entire time profited off of water, the public's resource. Well, they swear they put it to beneficial use, I suppose, but that remains to be seen. So we're going to put you on a little bit of a music in the background there. We'll be right back. Thank you for tuning in today.
Nevada, can we talk for a minute? Not politics, not noise, just home. W4Nevada Live, Nevadans talking to Nevadans. I heard a mother down in Clark say something ain't right at the school today. I heard a washer say the water's thin, and nobody tells us where the money went. Out and now they've been raising their hands, asking who keeps selling off the land. Stories watching all those power lines, wondering who pays when the bill comes due this time. We don't need a polished speech, we just need a place to speak. Bring your heart, bring your name, bring the paper with the date. Can we talk Nevada? Can we tell the truth tonight? From the valleys to the mountains, bring what's hidden to the light. Call it in, text it in, let your county say its name. 17 voices singing, but the heartbeat is the same. Can we talk Nevada? This is home, this is us. Real voices, real receipts, real follow through, real trust. Carson City, I can hear you too. Churchill's got a story coming through. Douglas knows what pressure feels like. Elko's still working under big sky nights. Esmeralda, don't you disappear. Eureka, your voice belongs right here. Humboldt, Lincoln Line, every small town still gotta shine. Lion, Mineral, Persian too, White Pine, we ain't forgetting you. 17 counties, one lone road. Everybody carrying a different load. If it's water, let's talk about it. If it's school, let's talk about it. If it's budgets, let's talk about it. If it's buried, bring it out. If it's power, let's talk about it. If it's land, let's talk about it. If it's public, don't hide it. Nevada, we're done being quiet. Can we talk Nevada? Can we tell the truth tonight? From the valleys to the mountains, bring what's hidden to the light. Call it in, text it in, let your county say its name. 17 voices singing, but the heartbeat is the same. Can we talk Nevada? This is home, this is us. Real voices, real receipts, real follow through, real trust. Say what you heard, say what you know, say what they try to keep down low. Bring that email, bring that file, bring that agenda they buried a while. Bring that picture, bring that name, bring that question they tried to shame. Rumors are leads, receipts are proof, and we follow the trail till we find the truth. Cause it's found it. We can talk, Washoe County. We can talk, Lily County. We can talk, Narrow County. We can talk, Hudson City. We can talk, Churchill County. We can talk, Dallas County. We can talk, Lyon County. We can talk, Story County. We can talk, Humboldt County. We can talk, Riga County. We can talk, Riga County. We can talk, Esmeralda County. One Nevada dream. Can we talk Nevada? Can we tell the truth tonight? From the valleys to the mountains, bring what's hidden to the light. Call it in, text it in. Let your county say its name. Civic voices singing, but the heartbeat is the same. Can we talk Nevada? This is home, this is us. Real voices, real receipts. Real follow through, real trust. Nevada, pick up the phone. This is your county, this is your home. W4Nevada live. Nevadans, talk to Nevadans. Real voices. Real receipts. Real voices. Vegas shine, that's the stage. But baby, we're more than the glow. From Carson City to the back roads, we got that old state soul. Churchill ride, clock keep moving. Douglas wind through the pines. Elko sky, Esmeralda dreaming. Every mile got a line. Hear that name roll slow, like a river through the sand. One state, one home, in every county band. We're Nevada, baby. Nevada all the way. We're Nevada, baby. From the night to the day. Carson City. We're Nevada, baby. Nevada all the way. Eureka Gold and Humboldt rivers, land of hills Washoe shake, white pine rising. Say it, baby, same sweet name. Hear that name roll slow, like a promise in the land. One state, one home, in every county band. We're Nevada, baby, Nevada all the way. We're Nevada, baby, from the night to the day. No, no, we're Nevada, baby, Nevada all the way. And when the horns start crying, we remember every road, not just the bright windows, but the ones that hold the Lord. Carson City, Churchill. Carson City, all the way home. We're Nevada, baby, Nevada all the way. We're Nevada, baby, from the night to the day. Carson City, we're Nevada, baby, Nevada all the way.
Hey, way out in the land of the setting sun. Yeah, 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 yeah. Where the wind's still wild and free, still free. There's a place that don't need permission to feel like home to me. Oh, follow roads where the dust remember names, names, names. Where the desert meets the hills. You'll feel it in your chest when you stand still. This land give 1,000 chills. Let it breathe. Home is an area. Yeah, it do. Home is the hill. Stand tall. Home means the sage and the pine of it. All of it out by the Truckee. Silver, silver, silvery rills. Shine on. Out where the sun's still shining. Always shine. Always. This is the land I love the best. Fairer than all I can see. Deep in the heart of the Golden West. Home means Nanetta to me. When the sun goes low at the close of day, golden hour, paint the whole west sky red, so red. My heart drifts back to the desert gray and the mountains over my head, over me. Moonlight dance in the shadow plan, soft, soft. Hear the night breeze slow. From the fawn and the doe to the morning glow, this the only place I know. I know. Home is Nevada. Yeah, it do. Home is the hills. Stand tall. Home is the sage and the pine of it. All are weathered by the Truckee. Silver, silver, silvery rills. Shine on.
All right, we're right back here. We are getting live. As you see the camera coming back there, I don't know exactly when they'll go live with audio. I have an errand to run. I'll be right back. Just going to be downstairs. So enjoy the court case. Look at all the gentlemen being so cordial and nice and civil. How law should be. We'll see you all in just a little bit.
So it's like.
All right, please proceed.
Yeah.
Back on the record. May resume.
Thank you, Your Honor. Brendan, may I have plaintiffs 534, please? And if you would go to 558. I think. Here. I think that you did talk about this in direct, and these are some of the water rights that were, if I may approach Your Honor, get a little closer.
Yes.
These will be schedule 7.1A, and it has a Coyote Springs water right, and these are all the groundwater rights you talked to with Mr. Hutchison on direct, and that total was the 3,140. You explained that. We can now page down a little bit, Brendan, to the next category, and 147 is. Was that described as potential water available?
Yes, that's what it says, additional water rights potential within the Coyote Spring Valley Basin.
Okay, so essentially, mathematically, it's a challenge for me. You're representing and warranting to the bank that there is available and or potentially available 150,000 acre feet of water available.
As described on schedule 7.1, I think this is X, yes.
Okay. And do you know from your own understanding and having worked with Mr. Whittemore that that's the amount of water he hoped he could achieve to build out the master plan community with the Park County and Lincoln County?
Is your question, was the number volume amount what he thought, or is your question in general, was this what he thought?
Yeah, in general, because Mr. Harvey Whittemore is guaranteeing this loan, in general, did you understand collectively that's the amount of groundwater he hoped to achieve to develop the master plan community for both Clark County and Lincoln County?
Yes, he had hoped for this, plus some of the water that was on the next schedule of things that were, I don't remember the word for the additional schedule, off-site water rights in the next schedule, because we looked at the Cane Spring water and the Tuffy Ranch, 11,300.
Brittany, can you scroll down so Ms. Cargo can see the next schedule?
The other total water rights potential within other basins. As we talked about, there were a few of those, the 1,000 for Cane Springs that he was looking at, as well as the Tuffy Ranch applications that were pending.
So in aggregate, you're better at math than what was the total either available and or hoped for acre feet of water to develop the master plan community?
So if we assume the 3,140, the 147,595, the 1,000 from Cane Springs and 11,300 from Lake Valley, on 150, 160, 162 in that range that was either available, potential, or other potential in other basins.
Recall that the total amount of units, at least entitled units for both Clark County and Lincoln County, was 159,000. Does that comport with your recollection?
I believe it's 159,600. Yes.
And certainly the amount of water both held and hoped for would have been sufficient to service the entirety of the master plan community over both Clark County and Lincoln County. Would you agree with that?
I'm not sure about the math on that, Mr. Sylvester. Meaning, I don't know. We would need the calculator you and I described that's sitting in my kitchen right now in my junk drawer, but I didn't bring with me. If you have one, we can use it. Excellent. As long as it's a basic one.
That's all I know how to work.
Perfect. So if you take 159,000 total residential units and we assume for the sake of this calculation only 0.71 acre feet, which is only really applicable to the Clark County side, but for the sake of easy math.
Mhm.
And so we multiply 159,600 by 0.71. That basic calculation would be 112,890.
We're covered. If Mr. Whittemore's hopes and aspirations with respect to additional water comes to fruition. Agree?
Yes, if all of what you see on 7.1X that could be used at Coyote Spring Valley, if everything came through. Yes, that would be a accurate statement.
Is that what Mr. Whittemore is representing to the bank, that we hope to get this water coupled with the water that we do have, and this will be sufficient to allow us to build a master plan community only if you know?
I think very generally, yes, that is the idea here. That said, it still remains the number, the first box at the top of the page, that's what was available for development. And so the bank knew that all that was available for development at that time was I'll call it the 4,140, because I don't think you and I would disagree that the water held by the GAD was intended to be used for the Coyote Springs community.
It was or wasn't?
Was the 1,000 acre feet was intended to be used in the Coyote Springs community.
We're working on the assumption that the 4,140 that we're talking about includes the GI.
Yes.
The one thing that we can agree upon, other than we would not to be here, is that as well. Agree?
Yes.
Okay. When you, by the way, because you are my wordsmith, what did you understand the word available to mean when you essentially approved the document for execution?
It's available for development. It can be applied to a map. It can be committed to a map, I think is the better word to use, because that's the word in the multi-party agreement. I think my memory tells me that it was available. It could be used on a map.
When you say available, I'm not parsing words with you. Do you mean legally available?
I hadn't thought about it in that way, but available, if it can be committed to a map, then it's legally available, I suppose. I'm not sure that saying legally available, I don't really know what that means. So I would just go back to available as in committed to a map under the multi-party agreement.
Okay. And so you're not saying, just so that I'm clear, legally available pursuant to the terms and conditions of the permit?
Objection asked and answered.
Well, yes, I'm saying that as well. I would say, I mean, the 4140, we have pursuant to the permits, and we know we have it pursuant to the permits and now certificates as well, but yes.
Okay, well, we perhaps agree on this as well. The base permitted rights were conditional in part on the monitoring, agreed?
Objection previously asked and answered.
In the context of this question of legal availability is why I'm asking.
Overruled.
Which monitoring plan, Mr. Sylvester?
Sure, you talked about on redirect examination, Ms. Hutchinson, 4542, and you talked about how you read the footnotes and some, but not all the studies, and that those findings were made by the state engineer and the ruling was issued, and you took great comfort in that. Remember that line of questioning on redirect examination?
I remember it on cross-examination and my deposition as well, yes.
And on redirect, it's
Yes.
yesterday. Okay, so when I'm talking about being conditional, you understand what 4542 says with respect to monitoring requirements, don't you?
I understand that there are monitoring requirements and that a subsequent monitoring plan was put in place that has been complied with, yes.
Okay, and we talked about that monitoring plan and its purpose before, so we won't retread that. So when you say legally available, had the monitoring plan been accomplished and the monitoring been completed at the time that you made the understanding and allowed the representation to mean that it was legally available under the terms of the permit?
What's the question?
Again, when you authorized or directed or advised Mr. Whittemore to sign the documents and you understood the word available to be legally available pursuant to the permits, did you understand at that point in time the monitoring had been completed?
I believe that the everyone knew that. Certainly Mr. Whittemore knew that as well.
Now, circle back to 1169, that order that was entered in 2001. Remember that?
Was it 2001 or 2002?
One of those 2 years, but we're talking about the same one. Certainly prior to-
1169, yes,
Right. Certainly prior to these loans.
yes.
Okay. And 1169, we won't spend a lot of time on it, required the pumping of existing rights in Basin 210, including essentially CSI's rights, correct?
It included the pumping of a whole slew of regional permits, yes.
Just shrink that region to 210. That was part of the order. It says pump your water out of Basin 210 or at least 50%, right?
A part of it. I just want to be sure that I'm not saying the only permits pumped were in Basin 210.
They weren't.
Okay.
I don't disagree with you.
Okay,
Everybody was done. That was the
regional,
Right.
yes.
Okay. So when you made the determination, when you formed the opinion that the water was legally available, monitoring hadn't been completed, and the pump test order in 1169 hadn't yet been started. Agree?
I'm just trying to remember when the pumping started. I don't remember what year the pumping started.
2010.
Okay, all right.
Just a couple more points on the loan and the allocation, or not the allocation, but the advancement of the facility. Recall we looked at the party agreements and they provided or they paid $130 million in total for the land, right? Roughly.
The number is what the number is. I don't remember. I think the whole entire schedule was a little more than that, but for the
Okay.
land, it's about that. I
Sure.
agree.
And part of the agreement, the first agreement and then the First Amendment required party to pay $88 million to CSI for the portion of the property it was taking down, correct?
Objection foundation without seeing the documents.
Sustained.
Do you recall, Ms. Cargill? And if you don't, that's fine.
I don't think it was 88 million. I think the number was different. I will agree there was a number. I don't believe it was 88 million.
We can spend the time, but I'm just trying to generate fresh recollection. The first one said 66 and then it was increased on the amendment to 80 or 88 in that range. Do you have any general recollection of that?
Objection foundation, Your Honor, without seeing the document.
Just ask her if she has a general recollection. She doesn't, she doesn't.
I don't, that number just doesn't ring a bell right now.
All right, whatever the number was, you understand because you testified to it that CSI couldn't take that money and run, right? They had to reinvest it.
Correct. It had to be used to help build I believe what the term was commercial improvements, the ones that CSI was obligated to construct.
$40 million of that was used to construct the golf course. Do you recall generally?
That is approximately the amount of money that it took to construct and pay the design fees for the golf course.
But it seems the proceeds of that party agreement were used to build the golf course.
I suppose that could be part of it. I guess I'm just trying to be careful. I don't know that the money from Pardee went from Pardee right to the golf course. It could have been that it supported something else and that money came from some other location to help pay to build the golf course. Do you understand my distinction?
Yeah, no,
Okay.
I accept your answer. Remember the direct cost summary that council admitted yesterday indicated that December 2007 CSI had spent $100 million, 101 or 102.
Yes, I recall that number. I don't remember if that was exclusive or inclusive of the management fee.
Okay, and so sitting here today, you don't know what all or any portion of one or more of the credit facilities were used in addition to the Pardee proceeds to fund not acquisition, but improvements prior to December of 2007.
I do not know what portion of the proceeds from the loan went directly into improvement costs in 2007 versus went for perhaps other overhead costs or entitlement costs or other things other than improvements into the land.
I just want to make sure that you weren't intending to suggest that all of the funds advanced or the credit facilities were used exclusively for CSI. And they weren't, correct?
I think you and I talked about this just before the break. No, I'm not saying that the money was used exclusively, whatever was drawn down. The drawdowns that would have been done on forms required by the bank and submitted to the bank that would have shown exactly what the drawdowns were being requested for.
And the credit facility was retired, wasn't it, when Mr. Sino came in?
After that, yes, after the 2011 agreement that we looked at, which Mr. Whittemore was released through, it was shortly thereafter, a year or two, that the entire loan, Mr. Sino, Mr. Tom Sino and Mr. Albert Sino paid it off entirely.
Okay, so the improvements that took place after 2015 through whatever that date was, 20 or 22, none of the credit facility proceeds were used to make those improvements, correct?
That is correct. It was all paid for by the two Mr. Sinos.
When the last, I think, question on the loan, when the bank took collateral in the permits, they received actually the permits, didn't they, to collateralize it? Attached to the deed?
There's a report of conveyance. Is that what you're referring to? The report of conveyance that's filed with the state engineer. You record the deed of trust and the security interest, and then you send those with the report of conveyance to the state engineer's office, as I recall. And then the state engineer's office, I believe, then sends out a document to the secured party, in this case, the bank, that describes what they have as security interest. And then when it's paid off, the reverse of all that is done.
I think we're saying the same thing, but attached to the deed of trust would be the permit, right? That's the collateral that you're taking a secured interest in.
Objection asked and answered.
I'm just trying to clarify, make sure we're on the same page.
I don't believe that the permit itself is attached, Mr. Sylvester. I believe a description of the permit is attached to the deed of trust as it's recorded. I stand to be corrected on that, but I believe it's only a description of the permit. And then that instrument, after it's recorded, is attached to the report of conveyance that goes to the state engineer's office.
And again, I'm just trying to prompt your recollection, but do you know, and you are familiar as a transaction where what the bank's underwriting would be in a particular loan or credit facility, generally speaking?
Objection, foundation.
I'll try again. You spent a lot of time with Mr. Hudson on redirect, indicated how involved you were and how you had negotiated lending transaction and promissory notes and guarantees, so worked with financial institutions. I'm just asking you if you know how, generally speaking, a lender would go through a due diligence process or an underwriting process.
Same objection, Your Honor, regarding underwriting of a bank's.
I would know on a very general basis. And I say that because I did not really represent lenders. I represented owners, let's call it, versus lenders.
Well, whatever is attached or not attached, it's fair to say that the security interest that attaches to the deed of trust would be limited to the terms and conditions of the permit, which it serves as collateral for. Agreed?
Objection, calls for legal conclusion, foundation.
Sustained.
You're taking a security interest in an asset, in this case, a permit, right? So they don't get any more or less rights than you give them with respect to the collateral. Would you agree with that?
Same objections.
Yes, I would agree. No different than real property. They get a title report and they look at it and it's the same type of process.
Got it. So let's switch gears and stop talking about bank loan documents. You spend a lot of time on direct and then on redirect talking about this historic basin by basin management by the state engineer. I'm just trying to orient you into the topic that we're going to be discussing. Okay. I want to hear in your words as the Senior Vice President, COO, and General Counsel, what you understand to be or to have been the basin by basin management.
At what point in time?
Well, let me lay a better foundation. You told Mr. Hudson on direct examination, as you were looking at Judge Yeager's findings of fact and conclusions of law, that was consistent with what you believed was the historic basin by basin management. I just wanted you to tell me in your words what you understood and what you said CSR relied upon as it relates to that historic state engineer basin by basin management.
Objection, timeframe.
The time frame is from the beginning of time, and I don't mean the earth, but from the 1997 time period that you testified yesterday to, as I made that objection, we went all the way back to when Harvey began, all the way through today's date. So that's the time frame that council has established for both of us. So with that time frame in mind, and if you can answer the question, in that broad of a question, what, in your words, was the basin by basin management employed by the city engineer?
Objection, mischaracterizes the prior testimony, my questioning.
Overruled.
I thought that Mr. Hutchison and I were talking about 2022 or 2024 and before. I didn't think it was to today's date. I thought that particular line of questioning was through, but we would have to go back and look at the transcript.
No,
But
Ms. Perry, you're 100% right. My apologies. From 2022 back to the first time that Mr. Whittemore acquired or began to acquire the water rights, which is 97, 98 time period. Comport with your recollection?
that's what I remember Mr. Hutchison asking me about.
And because the reason I asked you this is you said, we always believed, and we'll get to the we part, that this water was going to be managed on a basin by basin basis as it had always been done. But that's the construct of the question. I just want you to tell me in your words what you knew and what you understood, and perhaps what you would have advised with respect to that basin by basin management.
That the basin is as designated by the state engineer's office according to the prior USGS basin designation numbers. So as you and I referred to a little earlier, basin 210 would be the Coyote Spring Valley Basin. And that as you file for a water right, from the moment you file your application to get a permit, you file your application to acquire your water right, you're filing it into a basin. You file that into basin 210 and you say, I want to acquire a water right in this basin. Here's how I'm going to propose to do it. Here's where I specifically propose to do it from your point of diversion. And you tie all of your application and then later permit. Once it's permitted, when the state engineer issues that permit and they've reviewed it, they are saying that there is no conflict within the basin, and they are issuing you a permit in a specific basin. And that permit is then tied to basin, as we've been talking about, basin 210, let's say. And then as you file your proof of completion for whatever your well, let's just call it a well, your well, you then are filing that proof of completion related to basin 210 for your point of diversion in the well that you've done. And then your proof of beneficial use, you file that related to your basin. And everything that you do thereafter is then related to your basin. And your water rights are basin by basin. And when you pull up let's say your I'll call it, I think what the state engineer's office titles it that you can print is the abstract of title, and off of their website, and you go to their website and you put in basin 210, for instance, their little click and pull down box, you click on basin 210 and you hit search. It then will show you all the rights within basin 210. And then if you want to see the active rights, you click on the tab that says, I think it's called active, and you click active or current or whatever the terminology is that's used there. And the state engineer's website is as well directed on a basin by basin basis to pull up those rights and to look at them. And anything you do when you interact with the state engineer's office, you file an additional document, or if you're a lender and you file a pledge against a water right, it's going to be filed and show up for that basin on that permit. Is that the type of answer you're looking at, or did I just spend 5 minutes answering the wrong
No.
question?
Yeah, but it was your platform. I was trying to understand, and we'll ask some questions about that. What you understood to be the basin by basin management, and I think you have given me that answer. You gave me the process of how you apply for it and how you pursue it, winter diversion, and application forward. So when you say manage, that's what you intend on the basin by basin management of the.
Correct, and whatever statutes might relate to that as well. I'm not saying you do any of that independent of the statutes. So there have been for a long time statutes in place, and all of those statutes that relate to that basin apply as well.
Okay, and I'm going to draw an objection on this question. I'm gonna try it anyways. Do you have some understanding that the priority is managed on a basin by basin, regardless of, for instance, the hydroconnectivity of other basins?
Yeah, I'm going to object to that question. It's been asked and answered repeatedly over days of testimony.
This is in the basin by basin management discussion upon which this plaintiff is now relying on in the totality of circumstances to allege a taking. So I'm asking in that context.
Your Honor, the fact that we're in a different context doesn't mean that the question itself hasn't been asked and answered repeatedly. I just don't want,
In a different context.
Judge, I just don't want the witness to be held to, for the 6th or 7th time she's addressing this, to this answer. She's addressed it many, many times. That's the problem, as we've talked about many times in this trial, with asked and answered questions. It doesn't incorporate her prior testimony.
That's the national.
Overruled.
Thank you. Command.
Can you read it back to me if you have your monitor there?
I don't,
Okay,
but I, like you, have an aesthetic minute.
I do not.
The question was in the basin by basin management, that it was really to the priority, whether the priority was determined regardless of whether the basins were hydrologically connected. And again, only being.
For the time period we're discussing, if a person looks at the priority, as I described, for instance, the abstract of title that you can download from the state engineer's office, and you look at the priority, it has been basin by basin. You look at the priority that's in your basin, whether that's basin 183, 206, 210, whatever that basin may be, you look at that basin and you see what water rights are in that basin. And it shows the, basin 210, for instance, it would show the 2 permits held by Bedrock and that are in the alluvial, and then it would show Coyote Spring Investments.
And Mr. Hutchinson asked you to do 2022, did your opinion or understanding of the basin by basin management change after 2022?
No, not until Sullivan came out.
And as a result of Sullivan, do you have a different understanding now of the quote unquote basin by basin management?
The Sullivan decision, I think the words Judge Yeager used were upended what prior basin by basin management had been.
That was the 2022 we were talking about. Wasn't it after that point in time that your opinion changed when Sullivan came out? Is that what your testimony was?
Yes, it completely changed. The Sullivan decision completely changed how basin by basin management would go.
Okay, let's go back. Now we're going to just circle back on your definition as you understood it from whatever the earliest point in time was, 1997. When you left Leonard and Collins and you joined CSI, did you have an equity interest in CSI?
I'm sorry, what was the word you said? Equity?
Yes.
No, I did not.
Did you have a profit participation?
No, I did not.
Were you an owner in any regard?
No, I was
You're
not.
you don't have a proper participation today, do you?
No, I do not.
No equity ownership interest?
0. I have a salary from my employer, and that is all that I have.
You're not the landowner in this case, is that fair?
No, I am personally, no, I am not.
And when you were talking about your understanding of the basin by basin management during the time period that before your employment you're referring to essentially what Mr. Whittemore knew and understood. Is that accurate to say?
I would say,
Section mischaracterizes your testimony.
Overruled, she can say so, it is.
I would say that I was referring to what Coyote Springs knew, what all the people that were there who, when I joined Coyote Springs, talked to me and told me what they thought and they believed. And so it was not just what Mr. Whittemore may have said to me, it would be what other employees and persons at Coyote Springs shared with me as well.
You heard the term shot caller? Not shock, but shot caller, the person that makes the decision on behalf of an entity.
I got to object to that as ambiguous.
I use that because that's what Mr. Sino described himself as, but I'll just use an easier term that perhaps you can better understand. When you talked about a bunch of people told you or advised you about this basic management theory before you arrived, that existed before you arrived. You said I talked to some employees, but you also talked to Mr. Whittemore.
I spoke to everyone. I mean, it was an organization that spent time talking to each other.
I asked about Mr. Whittemore.
Yes, I spoke to Mr. Whittemore frequently.
And is your testimony before this court that Mr. Whittemore told you that this is going to be managed on a basin by basin basis because it's always been historically been done that way?
I don't know that Mr. Whittemore said those words to me in that order in a specific sentence. I know that as you and I talked about earlier, I did a lot of reading and I did a lot of review. I spoke to Mr. Savely, I spoke to Mr. Whittemore, I spoke to Mr. Mommer, Mr. Dirk, Mr. Reynolds, all the people that were employees, all of us who were dealing with all of the Coyote Springs matters, and that all formed a part of my testimony.
I think you answered the question, and I understand what you said, but as it relates to how you described it basin by basin management, and you said he didn't use words in that order in that sentence, but did he tell you that, for instance, we don't have to be concerned, or CSI doesn't have to be concerned about the impact that the use of hard water has on an adjacent basin?
I don't remember him saying that to me just like that, kind of like the series of questions you and I left my cross-examination with. I don't recall Mr. Whittemore saying to me the words exactly as you just described it. They were a part of conversations that we all had as we might sit around a table and talk about whatever was going on, whether it was Pardee, whether it was PGA, whether it was Nicholas agreements, whether it was the bank loans, all what Mr. Whittemore's, thoughts were for whatever the meeting was we might be having. I can't quote to you because I do not have a perfect memory. Exactly.
But I'm just talking, I get the stuff that happens after 2006. I was trying to compartmentalize when you came on, and I just want to know, did Harvey ever use the words, doesn't matter the effect that our pumping has on an adjacent basin, or words of like effect?
Objection, incomplete hypothetical, lacks foundation.
Overruled.
I don't recall Mr. Whittemore saying those words to me in the manner that you just described.
Did he ever tell you that you can recall from his opinion that the lines on the map drawn by the USGS don't matter with respect to priority?
I don't recall anyone ever saying that. I know the agreements that Coyote Springs, when I joined the company, the agreements that were presented to me that Coyote Springs had signed and had become a part of, and what Coyote Springs was doing. And I knew what actions Coyote Springs was carrying out.
The party agreements didn't contain a guarantee of water either, did they?
A guarantee by whom to whom?
By CSI to Pardee. It did not guarantee the availability of water.
Objection, lacks foundation without seeing the documents.
See, I'll use the foundation. You testified on direct examination that you were instrumental in drafting the party agreements, and even perhaps in part negotiating those. And so you have those in mind, because you talked about each one of those on direct examination, the amendment, the second amendment, this third, fourth, all the way through the ninth amendment. And so I'm just asking your recollection only. Do you ever recall seeing a provision in the party agreement where CSI guaranteed to party that water was available?
Your Honor, again, lacks foundation without seeing the documents. When I questioned the witness, she had the documents in front of her. Moreover, I asked one question with one document about party and my redirect. This is going way beyond the scope of my redirect.
Specifically, because she was so involved, it laid the foundation for that. As a transactional lawyer, if she has a recollection that it contained the word guarantee, if she doesn't, she doesn't.
Overruled. You can answer that question.
The word guarantee, although it may not be contained in the party agreements, there was a commitment, and I would need to see the agreement. There was a commitment that CSI committed to providing water for certain development, and then Mr. Whittemore negotiated with Pardee for Pardee to pay money for water to be committed for all of Pardee's single-family residential unit based on the 87.5% JFI share out of that you and I reviewed in the first amendment to the Pardee single-family agreement.
And I think you're referring to, and I'm only trying to refresh your recollection, that there was a requirement that CSI make a good faith effort to obtain additional water 5 years ahead.
Mr. Sylvester, I can't tell you that's what it exactly said. We would need to go back and read exactly what that agreement said.
Does Tom Sino still have an interest in the in CSI?
Yes,
Is he participating in the ongoing litigation to your knowledge?
Objection, ambiguous. And I caution the witness not to disclose any attorney-client communication or work product.
Do you on occasion meet with him, Mr. Tom Sino, regarding this litigation? Don't give me specifics.
on occasion we speak and he's been watching on Zoom. From not every day. I don't see his name every day.
One of the things, we'll shift for a minute, that you testified to is you remember that letter that council showed you, and it was the appeal by SNWA to the Clark County Commission's initial approval of the subdivision map.
Are you referring to the unsigned letter that was submitted to the Board of County Commissioners, or the one page that was submitted as the actual appeal?
Let me give you a reference point. That letter, whichever one it was, that had the reference to the 2006 hearing related to the GID. Whichever one that was.
Yes, I know the letter that you're speaking about.
And there was characterization about the assumption of the risk in that letter. And my recollection of your testimony was that it was either taken out of context or was inaccurate. Is that correct? The assumption of the risk aspect of it.
Yes, it was taken out of context and described to me incorrectly because I'd been at that public hearing.
Okay. And you hadn't read that transcript in what, 20 years?
I have never seen an actual transcript of that meeting. There's a general statement of it that's attached to the formation ordinance documents is what my memory is, but that the board of commissioners produced. I've never seen I don't think an actual word for word transcript.
So your responses were based just off your memory of having attended that very important meeting 20 years ago.
Objection,
Yes.
mischaracterizes your prior testimony.
Yes, it was a very important meeting, and certain things trigger a memory, and I remember that meeting.
Okay. Do you remember that meeting well enough to know that it was John Lash that was speaking and not Mr. Whittemore?
I don't recall that Mr. Lash was there. He could have been. I remember Mr. Andrews was there and was also speaking. I don't recall which of them it was that was speaking. I know that when Mr. Whittemore spoke, what I testified to yesterday, he did say.
Okay.
More or less, maybe not word for word.
In that order, in the sentence.
Correct.
Okay. All right. So you were here when he testified, seemingly 2 or 3 days ago, and he gave his testimony for a couple of days. And That was important testimony as well, correct? To you, to CSI.
When, I'm sorry, you've completely lost me. When who was where?
Mr. Whittemore testified before this court, whenever it was, beginning of the end of July or 1st of August, and you were here and you took notes, right?
I don't think I looked for notes. I don't have notes from that, but I was here, yes.
Do you remember Mr. Whittemore saying that in his opinion, in his view, a permit was a right to try?
Objection mischaracterizes the witness's testimony at the time.
You testified about it yesterday on redirect, that she would have never moved out of LSC if she knew that Mr. Whittemore thought it was a right to try. That was her testimony.
Those were counsel's words, Your Honor.
I'm gonna rephrase
Record
it.
speaks that Mr. Whittemore simply said yes.
Okay, I'll try again. Do you know, sitting here today, reflecting on the important testimony of Mr. Whittemore, do you recall him saying that he thought the permit was a right to try?
Same objection.
I recall that, what I recall is that Mr. Whittemore responded to your inquiry if a permit was a right to try, and he either agreed or more or less agreed with you. I recall generally that, yes.
And when you heard that, did you recoil and go, that I have never heard that before?
Yes, indeed I did.
And did you also hear him say that in his view, a permit was an opportunity?
Same objection, Your Honor. Words of counsel, not words of the witness.
Clarify it. I'm just asking if she understood, if she can get the same clarification or not.
You wanna show her where that testimony was?
I'm just asking if she recalls. If she doesn't, I'm not trying to impeach her. I'm just asking if she recalls that word coming out of his mouth in the context of a permit. If she doesn't, she doesn't.
Well, Your Honor, my objection is mischaracterizing Mr. Whittemore's testimony. It was a response to counsel's suggestion with these words. He's suggesting Mr. Whittemore independently testified.
What do we see from the witness? Whether she heard it or didn't hear it? I'm not impeaching her. I'm just asking if she has a recollection of that important testimony several weeks ago.
Your Honor, foundation, that's 2 weeks ago.
It's not a trick question. Either she does or doesn't.
Are you saying he did say that?
No, I'm saying, did he hear those words being uttered by Mr. Whittemore?
Right, go ahead.
I don't recall that word. No.
Again, I'm just gonna ask you about whether or not you heard him say that from a prior appropriation standpoint, the lines on the map didn't matter to him.
The same objections as previously, Your Honor.
I don't remember if he said it exactly that way or not, Mr. Sylvester. I don't recall that he, in his testimony in court, said that in that exact way. I know you talked about the USGS lines, and I don't recall if the way he said it was what you just said.
When you, in whatever words and the order in which they appeared, or it came out of his mouth, did you do the same thing, sort of recoil like, that's news to me?
I don't know that if he said that, I don't know that I just don't remember that particular testimony in that order.
Okay.
If we could pull it up and read it, that would help refresh my memory, and then we could talk about it.
Very good. When you were, I know that you came in 2006, and then I think Albert Senior Jr. came in 2008. And I think you said at some point they became joint managers, perhaps even with Tom Sino, right?
Who became joint
Harvey,
managers?
Tom, and Albert.
Yes.
Was Harvey still actively involved in the project, the development of the master plan community during the time period that we just discussed?
The three of them did a lot of interaction together once Mr. Albertino was involved.
Was Mr. Whittemore still actively involved in the development?
Yes, I would say they would equally make decisions on things.
Did you ever talk to or advise Mr. Sino in the capacity, not as a lawyer, but as the COO or the senior vice president, that the water permitted under the base permit was a guarantee?
I do not recall using those words and telling Mr. Sino it was or it wasn't a guarantee.
With respect to water related issues, and let's just say from the time you came on until Mr. Whittemore left. Who was making the decisions with respect to applications to extend beneficial use or pursuing a change in the point of diversion or changing the manner of use vis-a-vis the parties that were at that point part of CSI?
Which years did you just say? I apologize.
No, I'm talking about 2006, 2000 until Mr. Whittemore left. Then 11, we said, you have Mr. Sabley, who is a water rights attorney, right?
To me, that he is more of a water rights attorney than I am. I would say that.
Well, you went through a number of documents on direct and then cross, and we see Sabley signing these applications and these changes in point of diversion and these a number of different documents.
Yes,
So he's one of the folks, one of the people at CSI that's essentially managing the water rights for CSI. Would that be an accurate characterization?
it would.
And the other person would be Harvey Whittemore. He would be also involved in managing the applications, correct?
Yes, and I would add to that as well. Related to the ranch properties in northeastern Nevada, we also had a gentleman by the name of Mr. Doug Carragher at the time, who he would not fill out the application or sign it, but he would be working with Mr. Whittemore and Mr. Sabley and Mr. Mommer in that process. And they would all work on those things together, and that's what they would do. And
You're not taking direction from Albert Palmacino with respect to managing or overseeing the management of water rights during the time period that Mr. Whittemore is still there. It would have been either Mr. Sabley or Mr. Whittemore.
I was aware of what was going on and had available to me the various schedules and permits and documents. But Mr. Sabley was the one who would ultimately sign, and he actually drives to Carson City and files them, or at least he used to at that time frame.
Right. I'm not trying to diminish your role, but you're not involved in the management of water rights other than maintaining the schedules. That's Mr. Whittemore or Mr. Sabley.
Objection asked and answered.
Overruled.
And Mr. Mommer and Mr. Carragher.
Would you defer with respect to water related issues, defer to Mr. Sabley and Mr. Whittemore during the time period we established?
Objection ambiguous. Foundation.
Overruled.
I would defer, but I would be involved and ask questions and be a part of.
Sure.
Again, Mr. Sabley is more of a water lawyer than I am, but I'm not afraid to voice my opinion and have a conversation.
And so too is Mr. Whittemore, more so than you, a water lawyer.
I would agree with that, yes.
You've never testified before the state engineer.
I only hesitate because I don't remember if I don't remember if I testified at 1303. I don't think I did, Mr. Sylvester, but I think I would remember that, but it feels like a long time ago right now.
In the time period that from the time you came to be employed through 2020, did you ever have any direct communications with the state engineer beyond the public workshop process and dealing with Mr. Tim Wilson?
We spoke about this the other day, and
I'm just gonna belatedly object, asked and answered.
Overruled.
are you asking if I had met with Mr. Wilson during that time frame?
I'm trying to get to, let me try a different question. Do you recall when would have been the first time you ever met with any state engineer with respect to the water rights?
I know that I spoke to Mr. King at various workshops because he attended many of the workshops himself personally. And I know that I've spoken to Mr. King at workshops. You had asked me the other day, and I've thought about it, and I do not recall having met with Mr. King, with Mr. Sino, or with Mr. Chen. I may have. I know absolutely that I met with Mr. Wilson, as I stated, with Ms. Fairbank and Mr. Balatin, and could have been somebody else from the state engineer's office, and Mr. Sino the third.
Okay.
And public workshops, it would not be unusual for any sorts of number of people to talk to the state engineer or other of their staff members that were present.
Let's do it by exclusion. You never spoke to Michael Turnipseed. He was the author of the 4542.
No, I've never spoken to Mr. Turnipseed.
Not Hugh Ritchie, who wrote 1169. To your recollection.
Not at the time of 1169. I may have met Mr. Ritchie at some point past that. I'm not sure it would not have been a substantive conversation, Mr. Sylvester, but I may have met him. I just can't recall right now.
Tracy Taylor,
I don't think I've ever met Mr. Taylor.
Adam Sullivan,
Oh, yes, I've spoken to Mr. Sullivan.
in the context of the the public workshops.
Public workshops, at meetings or at legislative hearings that we were both at. I've spoken to Mr. Sullivan. I don't think ever in a one-on-one meeting, maybe in a group with some others at a public meeting of some sort.
Brenda, can I have state's proposed 3933, please? And Ms. Cargill, this relates to, you talked about it on redirect a little bit, I think, what's been referred to as the 5918 hearings.
Okay,
I can't recall, did you say you were at that hearing or you weren't?
I was not at this hearing.
Brenda, if you go to 0186. Get to who the speaker is. I believe this is Ms. Judy. Have you read this transcript before, Ms. Bergen?
I have read parts of it. I have not ever sat down and read it cover to cover.
Brandon, would you go to 004, just so I can orient Ms. Cargill into who the speaker is? Thank you, Mr. And you can see Harvey Whittemore, and his testimony begins at 129. And it looks like the next speaker is Jeremy Aguero at 187. That appeared accurate to you, at least that
Oh, I was trying to see where Mr. Whittemore's name was. I was
17?
I see that now.
Okay.
Yes.
I just want to orient you to who the speaker is, so that we look at that.
Oh, may I ask a question though? I don't understand. What does it mean by Mr. Reed, by Mr. Benzonet?
I think that was a direct and cross-examination. Whoever was asking the questions.
Interesting. Okay.
You think it's interesting?
Oh, that Mr. Benzonet was questioning Mr. Whittemore. That's all.
I don't know who they are. But now go back to 0186, please, Brendan. Mr. Taylor says at line 6, so I understand, I mean, you need to know how much water so you can continue with the development, but it sounds like you're not going to even want this water for 10 years. And if you go to the bottom and the paragraph is at line 20, and if you just read that into the record that continues on to 0187, please.
We do not have an ability to forecast demand within 100 or 200 units. And therefore, what we have to do is say, we've got this. We may mix and match what the pumping is. As you know, Order 1169 suggests that we may have to cut back on pumping in Coyote Springs if there's an impact to the Moapa Dace or to the springs. And therefore, we might replace a pumping cycle that suggests that we may trade with the Southern Nevada Water Authority for resources that they have.
Thank you. We're almost done. Just get back up. Pretty go a page back up, please. Can you direct on that? Yep. What line, Matthew? Did you understand, having read that from Mr. Whittemore, that at least he was concerned on that date that Order 1169 might require a reduction in pumping in Coyote Springs?
I know what this transcript states and that it says on pumping in Coyote Springs. So if it could be shown that the pumping in Coyote Springs specifically was impacting, I believe that's what is being said with those words.
Okay. And did you have that understanding at the same time? When I say at the same time, as of the date that this testimony is being given, that Order 1169 may ultimately result in the regulation or restriction of the base water rights?
I'm not sure that Order 1169 could have, because Order 1169 was related only to the applications for the additional water rights. But I don't know that could have happened just from a due process perspective, but that's getting beyond what you asked me.
One of the things you talked about on redirect with Mr. Hutchison was the topic of the pumping by Moapa Valley. And I think, as I recall your testimony, you indicated that Moapa Valley was being allowed to pump 80 million gallons per month. Is that the number you used?
It's Moapa Valley Water District pumps whatever they happen to pump, and I read their manager reports every month to see what they have been pumping and from what well. The fact that it's however many millions of gallons that I read yesterday, I think it was 82 some odd million, 82 or 83. I don't know what that equates to in terms of what Arrow Canyon well is. I've not done the math, Mr. Sylvester, to say, oh, that's so many acre feet. Nothing like that.
But
I look at their manager's report just to see where are they pumping from right now.
why? That's my question. Why are you undertaking that monthly or whatever that periodic review of those pumping reports?
Because Coyote Springs has been attempting for some time, as you and I've talked about, to get some maps signed to be able to move forward. And Moapa Valley Water District's rights are junior to Coyote Springs in the, whatever it is, 7 basin area. And Moapa Valley Water District uses its water in an area outside of the lower White River flow system. And that area has homes, it has businesses and growth. They build homes, they have new businesses. They're allowed to pump and to keep pumping, and no one, the state engineer specifically, has not taken action and told them no, has not failed to sign any maps that they may be presenting to the state engineer. And they continue to pump. And they're junior to Coyote Springs' rights, and Coyote Springs is unable to have a map signed.
Are you testifying to this court that the state engineer approved a subdivision map from Moapa Valley, allowing it to use the permitted junior water. Is that your testimony?
I don't know if they have signed a map or have not signed a map. I'm saying that Moapa Valley Water District provides water within its service area, which includes the Overton area, which is outside of the Lower White River flow system. And I know that because I read I can't remember if they call it an integrated resource plan, but their water supply plan, and it describes their service area.
Okay, I thought you were suggesting that they're being treated differently, that they got maps approved and you didn't, but that's not your testimony.
They may have, I don't know.
It may not have.
They may not have,
Okay.
I don't know.
Okay. And they are allowed to pump but so too is CSI. CSI is pumping 50 million gallons a month for its golf course, right?
The distinction I would make is that Moapa Valley Water District is pumping for homes and businesses. Coyote Springs has been told you can't get a map for a home or business because that's a permanent use and the golf course is a temporary use.
Just so we're clear, you don't have any information to tell this court today that the state engineer has given them a permanent use of that water to supply homes, right? You're just saying they're using that water to all the things you said. Is that accurate?
That is accurate. Moapa Valley Water District is using that water for its service area, which includes homes and businesses and all of the pertinent uses within its service area.
But the state engineer hasn't certified a permanent use of that water for residential, only if you know.
I have no idea if they have or they have not.
And the number that I think you said roughly 50 million gallons is about 586 million gallons annually that CSI pumps out of that well.
Mr. Sylvester, I don't know it in gallons. I know Mr. Sabley probably reports it in gallons. I know it in acre feet. Coyote Springs pumps somewhere between 1,500 acre feet and 2,000 acre feet, depending on the year, out of its wells 1 and well 4 together combined.
Okay. There's a lot of other permit holders that are actually using their water in the super basin, aren't they?
Within the Lower White River flow system?
Yes, ma'am.
Yes.
All of them are using their water. But to your knowledge, I mean, you look at the pumping logs or what other publicly available information is to see who's pumping and how much. Is that fair?
Well, I would say if we went back and looked at that priority chart that was published that shows the 2017 pumping, I think we would see that there are a number of people who, at least in 2017, it only shows 2017, are not pumping their water at all.
But all the folks that are pumping after 1309 continue to pump. Right?
Perhaps.
Nobody's been restricted or their flow hasn't been diminished since 1309. Would you agree with that? From your understanding?
Objection, foundation, calls for speculation.
You look at the websites, do you look at the annual duty or on periodic review of the duty of the pumping that's being taken place?
No, I actually don't know how to do that particular
Let
thing.
me ask you a broader question. I think I will. I don't think I'll get an objection. I will. Do you know, foundation, by your own knowledge and understanding, that any flow has been restricted to any permit holder since the issuance of 1309?
I don't know.
When CSI pumps the water for its golf course, that's ultimately returned back into the ground, isn't it? It goes back into the aquifer. Again, you're not a hydrologist, and only if you.
Objection, foundation, calls for speculation.
That's why I say only if she knows.
Overruled.
The water that, and again, I'm not a hydrologist, I'm not a scientist, which you and I have confirmed several times. But the water that Coyote Springs pumps comes out of the carbonate aquifer. And so when we water the golf course, because we don't have homes, so it doesn't go into a wastewater treatment plant. When we water the golf course, the water goes into the ground and it would sit in the layer of the earth that is above the carbonate aquifer, which is called, as I understand it, the alluvial or the alluvium. And I think that on my very non-scientific basis, that it takes a long time, far longer than my lifetime will ever be, to go from the alluvial into the carbonate.
All right, Brenda, can I have exhibit 3848, please? I'm sorry, 3331. We're talking to Mr. Hudson on direct exam, or I should say, redirect examination. And you laid out some facts why, in your view, at least as I understand it, Lincoln County and Clark County are really separate and distinct developments. Do you recall that line of questioning and your answers?
Yes,
And you gave the examples of maybe zip codes or taxes and voting, I think, were some of the things you suggested. Is that consistent with your recollection?
among many other things, yes.
You know, Ms. Cargill, that the Part E and CSI, as part of their various agreements, required that there be a set of covenants, conditions, and restrictions.
Yes, that were recorded, as I recall, before my time, but also before the first loan agreement. I think it was before the first loan agreement was entered into.
How does that inform your answer, just from a timing perspective?
No, it's just a memory that I have.
Okay.
That's all.
I thought you were going to suggest they were related somehow, but I understand just what it is. And you've read these CCNRs?
I think the last time I read them probably was about 10 years ago.
But it was a requirement because Part E, who had an option on both Clark County and Lincoln County, wanted to make sure that there was some uniformity with respect to the development. Would you agree with that?
I was just pausing because I'm trying to recall what Mr. Savely has, or Pardee has mentioned about who was a part of negotiating these CCNRs. I don't recall whether or not Pardee was a part of negotiating the CCNRs or not from the 2005 timeframe. That was my hesitation.
It's actually an attachment to the purchase sale agreement. I'm happy to show you, so you had a doubt of that, but it's a condition that they be agreed upon and recorded in both counties. Do you have that recollection without seeing the document?
I don't. I couldn't take your word for it. I just don't happen to have that memory of that very first Pardee agreement and what its exhibits were right now.
The agreements by between Pardee, if you know, I can recall, required that the development agreement be recorded. I'm sorry, the CCNRs be recorded in both Clark County and Lincoln County.
Yes.
And do you know why? I mean, why there was the requirement to have these CCNRs recorded in both Clark County and Lincoln County?
Other than the fact that Pardee's option extended into the Lincoln County property because Pardee wanted to, because they're a long view towards the project and they wanted to lock in their purchase price. So therefore they wanted to lock in that county, which was separate from Clark County, any of those terms and conditions. So they knew what to expect.
Well, again, reflecting back some time ago when we started your process, we talked about how you had drafted CCNRs and you were familiar with CCNRs, but isn't a CCNR required part to have some sort of uniformity in a community?
In part, that's oftentimes why. I mean, there's many other reasons why a person has CCNRs, but yes.
Mr. Kennedy once argued for this court that was to make sure that the paint colors would match. Do you remember that testimony or not testimony? I'll withdraw the question. Can I have you turn to 0011, Brendan? I want you, if you would, before our break, just read in paragraph F when he gets there. Did you see the front page, Ms. Cargill?
This was the Clark County CCNRs.
Yeah, I said, did you see the first page? I didn't see you see it. I want to make sure you know which one we're looking at.
If it's the Clark County, yes, I saw this. It's recorded March 31st, 2005 in Clark County.
Okay, and then we're gonna go to 0011 and you're gonna read in paragraph F and then we'll probably go to lunch. Maybe.
The Coyote Springs Master Plan community is being developed on lands presently lying in Clark County and Lincoln County, Nevada, parenthetical Coyote Springs and parenthetical. Coyote Springs will be developed under the provisions of Romanet 1, the Coyote Springs Development Agreement approved by Clark County on December 18, 2002, and recorded April 28, 2003 in Book 20030428. Instrument number 02990, parenthetical CC Development Agreement, and parenthetical Romanet 2. The specific plan approved by Clark County on December 18, 2002, parenthetical specific plan, and parenthetical Romanet 3. The Coyote Springs Development Agreement approved by Lincoln County on December 20, 2004, parenthetical LC Development Agreement, and parenthetical, and Romanet 4, all related documents governing development of Coyote Springs in Clark County and Lincoln County, Nevada, each as now or from time to time modified or amended. Declarant intends the LC Development Agreement and the related documents governing development in Lincoln County to be consistent with the provisions of the CC Development Agreement and related documents governing development in Clark County to provide a seamless community across county lines. Further, Coyote Springs will be developed subject to the provisions of the Coyote Spring Investment LLC Multiple Species Habitat Conservation Plan, parenthetical MSHCP, and parenthetical, and related Section 10 permit issued pursuant to the Endangered Species Act. Each is now or from time to time modified or amended.
Did you understand, Ms. Cargo, when you read these, that was the intent of CSI, is to have a seamless community across county lines?
For it to perhaps appear from the outside as though it were seamless, that the architectural restrictions may be similar.
The paint colors.
To your point about the paint colors or styles.
Offer proposed 3331, please.
I have no objection, Your Honor.
It's admitted. And at this time, we'll take our lunch break.
Thank you, Your Honor.
Thank you, Your Honor. Reconvene at 1:15. We'll reconvene at 1:15.
1:15. Thanks, Your Honor.
All rise.
Yeah.
All right, we'll be going to that lunch recess right now. You know that we'll be back at 1:15. Typically, I cut the feed at this time because I've got notes, I've got stuff, I got to check back in with my kiddos. I homeschool, by the way, because I also do not trust Nevada's educational system. I've been doing that now literally 8 years, going on 8 years of homeschooling. Don't trust your kids with these schools. They're only dollars, to be honest, and I think it's like $12,000 per student is what they get in federal funding, and that's if they don't say, oh, they're a second English is their second language, a ESL learner, or some sort of like disability or autism, or it's always some Title IV stack or some federal subsidy stack that they can get off of your child. They love to go after kids that aren't American citizens, that don't speak English, that are autistic, that are handicapped. They stack, and that $12,000 per student just became $60,000. Are they going to use it to get a great teacher or take care of anything? No. So my goal for education out there is to make sure that the dollars are being spent where they're supposed to. But with this top-heavy administration, it's not going to happen. So once again, thank you for tuning in to W4Nevada Live's continuing coverage of Day 11, Coyote Springs LLC versus the state of Nevada in a $1.5 billion takings claim and bench trial. It is very important if you are a Nevadan and or care about water, because these will set precedents and be able to be used as reference in cases moving forward. So I don't believe for 1 second that we should have to pay for a developer or someone that put into a speculative bubble of development or a project. Same thing with these data centers. I don't believe we need to be responsible for all these data centers. 75% abatement, 2% tax cap for up to 20 years. This is ridiculous, ladies and gentlemen. Stop building things off our back. And then when Nevadans don't want to, we're like, we don't want data centers. They're like, you'll take data centers. And here we're like, we don't want you selling our water and gaining millions and hundreds of millions of dollars off the public's resources. This is crazy. Why are people out there racing to get the water so they can develop it so they can then turn around and charge people for 20, 40, 50, 100 years? It's the public's resource. The fact that people are capitalistic and advantageous in nature, and what you can tell pretty much from this case, at least in my opinion, which, by the way, Jeffrey Sylvester, awesome lawyer. Thank you so much for being there on behalf of the state. I really see it going our way because you built such a great foundation, and you've clearly shown, in my opinion, from an outside perspective, that the state was clear and the rules are clear. And somebody's bitter that they lost out. And it seems like they owe a lot of people that they went around and utilized our water, our resources as their bargaining chip. And that never happened for them. However, it seems like they've also been able to, for more than, I don't know, what is it, 1998, damn near 20 years, 1998 to 2008, 2000. Yeah, look, it's a long damn time, bro. And you're talking about they've been making hundreds of millions, if not billions of dollars off of our resource, pumping and selling and pumping and selling and pumping and using and pumping and selling. Ladies and gentlemen, that's my opinion. It's not the expressed opinion of anybody else, but here we go. And remember, at the end of the day, like I always say, we're not just Vegas. Read the whole map.
We're not just Vegas.
We'll be right back.
Read the whole map. Read it. Lights don't run the state. No, they don't. That's a small cap. Small cap. We're not just Vegas. Look around. Past the neon haze. Past it. 17 counties. All of them. Different lives, same place. Same soil. Same soil. They think Nevada starting in on the strip. That's like judging a book off the cover it get. Vegas loud, yeah, but that's just a slice. Plenty state left once you drive past the lights. There's towns where a handshake still means something. Where folks know the land and the seasons are blunting. Where work don't trend and patience is learned. Where votes still matter cause people return. We don't all gamble, we don't all party. Some folks wake early, boots, dusty coffee. Some places quiet, some places spread. Some rows, long conversations with your head. The state breathe wide, not stacked in a frame. Don't shrink us down to a postcard name. We're not just Vegas, no way. No way. That service talk, surface. Real Nevada, out here. Outside the walk, outside. This land where the sky feel heavy or blue. Where the silence louder than the news. Places built slow, no rush to impress. Where people still show up, not just express. Some counties keep food on shelves you don't see. Some keep water, man.